All right, let's call the meeting to order. Welcome back, everybody. We're on the final afternoon of the final interim committee meeting, and the next bill for our consideration is 24 LSO 0273, Public Service Commission Integrated Resource Plans. Mr. Anderson.
Good afternoon, Mr. Chairman. Josh Anderson, LSO. So these next series of 4 bills, we have our ones that the committee hasn't seen before, all the ones we talked about this morning, we had discussed back in September. These next bills were all requested at the end of that September meeting at the suggestion of the Wyoming industrial energy consumers, and then the committee requested all of their suggestions that they had brought to that meeting. This first bill is related to the review of integrated resource plans. This is based off of Utah's law. So just to go very quickly through the bill, on page 2, requires the commission to engage in long-range planning regarding public utility regulatory policy. Pursuant to that, the commission shall require each affected electrical utility, and that's defined at the end of this bill, to file any action plan developed as a part of the affected electrical utilities integrated resource plan. And the commission is required in subsection B to adopt rules providing a process for the review and acknowledgement of an action plan and integrated resource plan. The rules shall provide the review be conducted in accordance with the contested case and practice procedures, determine whether the plan and integrated resource plan should be acknowledged, authorizes the commission to provide guidance to the utility, and specify that acknowledgement of a plan does not include a determination of prudence or presumption of rate recovery, and then give flexibility to make changes in the action plan between periodic filings. And then, Mr. Chairman, subsection C, the definitions. You see the first definition there, affected electrical utility means a public utility with at least X number of retail consumers. The Utah definition was for 200,000 retail customers. And so the committee may want to consider that number in moving this bill forward. And then you see on page 4, Mr. Chairman, a definition of integrated resource plan, which would include the demand and energy forecast by the utility for not less than 10 years, the options for meeting the requirements shown in its load and resource forecast, including demand side and supply side options, and a brief description of each option that was considered, their assumptions and conclusions, a description of the economic consequences of the plan, and any other data required by the commission. So that's the bill, Mr. Chairman. I'd take any questions.
Thank you, Mr. Anderson. Any questions? Representative Newsom.
Thank you, Mr. Chairman. On page 2, there's talk of acknowledgement and should it be acknowledged? And I wondered how that works. If it's not acknowledged, is it a try again? Is it a this is unacceptable? What does the term acknowledgement mean? Thank you.
Josh, if you can.
Good question, Mr. Chairman. I don't know that I'm clear, except that that's the process that Utah follows. It's not an approval necessarily. It's just an acknowledgement of the plan. There's probably other people in the room that might have a little more detail on that, Mr. Chairman.
Thank you very much. Anybody else? Any other questions for Mr. Anderson? Thank you, Mr. Anderson. Mr. Burbridge, did you want to talk about this one? Welcome.
Yes, thank you, Chairman Case. Just first, I guess I would try to address Representative Newsom's question as regarding the acknowledgement. I think that the commission looks at that as something less than an approval. But just to define exactly what that means, as I sit here today, would be hard pressed to do that. But it does seem to be something less than an absolute approval of the plan, which quite frankly, I don't know that we would want that anyway as a Public Service Commission, as the more important approvals come at the applications for certificates of public convenience and necessity, and then, of course, in any tariff proceedings and other rate proceedings like is going on right now. So an acknowledgement is something I think that the Public Service Commission could work with and probably clarify through rulemaking. I would point out that two things, and I know this isn't in the draft, but the 200,000 number for the customers, to make this applicable to any particular utility in Wyoming is, I'm certain, a bit high.
Yeah,
As-
kind of big.
A bit, and perhaps an alternative method for determining who this would be applicable to is perhaps looking at kilowatt hours of sales. And if I get this wrong, I'm certain that the WIAC representatives will correct me when they come up here, but it seems to me, at least at a federal level, that the number to include people on 111D type regular, standards is about 500 million kilowatt hours of sales a year. The other thing I would point out, and I don't know the answer to this, except that this is limited to electric utilities. There is some, perhaps would want to be some consideration as to whether or not it should include gas utilities. I believe that Dominion does in fact file an IRP with us on an annual, whenever they have to file one in another state pursuant to our rules. I don't think the Public Service Commission really has a position on that either way. And as I sit here, and I know we're looking at this draft legislation, frankly, at the suggestion of the chairman, I can't remember if it was the last meeting or the meeting before. I think the last meeting. So for that reason, we aren't opposing this bill, oh yes. The last thing I would point out is that if the intent of the contested case language is to have the commission hold an actual contested case hearing with witnesses in the room being sworn and court reporter and all of that, we simply don't have the staffing to handle an IRP matter on every application to have it be resolved in that type of trial type setting. Although I think technically it could be read, and I believe that anything that gets filed with us is a contested case to a degree. Even if it's a day-to-day matter, but many times IRPs are handled in our regular open meetings through presentation by the affected parties and any other public members currently that want to comment on the IRP, and then the commission takes its action there. So we may need some clarifying language on what do we mean by a contested case hearing, and I would stand for questions.
Thank you. Questions for Mr. Burbridge? Senator Barlow.
Thank you, Mr. Chairman. So within the bill draft, there are two definitions. One is affected electrical utility, and leaving aside the number of customers or a kilowatt usage. And you kind of touched on this, talking about the Dominion being a gas IRP. How many companies would be impacted by just the IRP process? How many electrical utilities would be affected by that currently in Wyoming? And then I'll have a follow-up. Thank you.
Currently,
Go ahead.
Chairman, Senator Barlow, currently we see IRPs from Black Hills. If that's what the question is leading to, and Rocky Mountain Power, Dominion, MDU, and that may be it. Now, the one thing that if you're looking at perhaps a kilowatt hour of sales, that may encompass like a Precor, who's a cooperative that I don't believe we've ever received anything like an IRP from them. And so I suspect that the cooperatives would have something to say about any legislation that would, start requiring every cooperative in the state to file an IRP with us. And I don't know that that's what was intended with this sort of legislation for IRPs. So I may be missing one or two that we review now, but it certainly affects more utilities than Rocky Mountain Powers. So.
Follow up?
Thank you. Thank you, Mr. Chairman. So FOB's second definition is an integrated resource plan. And there's a list of things that are included in a integrated resource plan. And if you haven't looked at it, I certainly appreciate that. But because I want to know, is this generally what is included in an integrated resource plan? Or does the commission actually have an expectation, a list of expectations that they would put forth or when somebody submits? So what I'm trying to say, is this consistent with what you might already be requiring in another way? Thank you, Mr.
Mr.
Chairman.
Burbridge.
Chairman, Senator Barlow, the integrated resource plans that we receive, we do not currently have a list of what's expected to see in them, although they are very comprehensive. And without having looked very closely at this language here, I suspect that all of that's covered, particularly since, for instance, in Rocky Mountain Power and Dominion's case, if they're filing an integrated resource plan in Utah, they are following this anyway, so we would get this. And we have explored to a certain extent and have seen WIAC made a proposal for an IRP rule-making process and filed a petition for us to engage in rulemaking, which I believe was declined some years ago. But in looking at it again, because we have been exploring that based out of the 2019 investigation into Rocky Mountain Power's IRP, that order discusses the commission entering into rulemaking. And in looking at that, we were then again looking at certain requirements that we expected to see in an IRP, but we haven't gotten further than that.
Okay, one more.
Thank you, Mr. Chairman. So since you opened up the Utah neighbor in this, has you or the commission had any interactions with Utah about the implementation of this law and how that has occurred, et cetera? I do not know how long it's been in effect. So that's the first question. I don't know, but implementation in Utah. Thank you, Mr. Chairman.
Chairman Case, Senator Barlow, to the best of my knowledge, nobody in our office has discussed this particular legislation with Utah. I was asked to provide a copy or the citation to Utah's law to LSO so that they could draft this, but we have not coordinated this with, to the best of my knowledge, with Utah staff.
Thank you. Representative Ottman.
Yes, thank you, Mr. Chairman, and for whomever could do this. What I'm wondering is, this looks to me like nothing's ever been done before. And so are we implementing things for new companies, or like with it says a review, has there not been reviews before? Or I guess I'm not understanding the genesis for where this is coming from or what it's going to do. I don't have that background.
Okay, Mr. Burbridge, I'll let you tag on. Electric companies file their integrated resource plan with the commission. I don't think it's annually, I don't know what it is, but it's every few years they come up with an integrated resource plan, which is how they intend to meet the load and the demands on the system going forward. And it's an elaborate document. It talks about the resources and when those resources will come online and when things retire, like coal plants, and when more wind comes online. And it's their planning document. There are constraints that they produce the planning document in response to constraints about regulation of when coal plants go out or when other resources are required. And it's a total package. This bill, the basis of it is that right now, if I can jump back a little bit, in the electric utility world and in general, it's sort of a cumulative process, and not everybody agrees with me on this, but the first thing a utility does is file this integrated resource plan. And there's no real challenge. You don't cut to the nuts and bolts. It's filed, the commission accepts it, and they may discuss it, but it's not really dug into. So the integrated resource plan goes on the shelf, and this is my opinion. And then when you start working towards the goals in there, the next step is when there's a piece of equipment, or perhaps a type of generation or a transmission line or whatever that's in the integrated resource plan is actually constructed. And they want to bring it in and potentially recover money from customers for that. They will seek a certificate of convenience and necessity. And at that point, it's sort of, we never challenged the integrated resource plan, and they have as evidence that they will say, well, we think this resource is necessary, and it was in our integrated resource plan. We told you we were going to do this. So don't question us, in essence. They might disagree, so you'll certainly get your chance. So we told you we were going to build more wind. Now and we're going to need transmission for that new wind. And so here we are 5 years later. We're building the transmission. Now we're going to build the wind. And we want a certificate of public convenience and necessity. Well, commission grants it. Part of the reason is it was in their plan. Everybody knows this. Now the next step is it's got to go into rates. And now there's a rate case. And so it ends up having elevated presence and less scrutiny, I argue, than if we had scrutinized it at the very front legally. I think you'll hear testimony, and they're going to give it, that the commission still has the ability to not approve that. But I say all these things are very cumulative. They sort of set you in a groove as to where you're going to end up. And the integrated resource plan is the first step. Mr. Burbidge, I know you probably don't agree with that completely, and that's fair enough. Go ahead.
Chairman Case, actually, I think there is a lot of signaling that goes on at each stage of the proceedings. And it starts with the IRP. I think that the greatest effort that the Wyoming Public Service Commission made, as far as not only, previous to 2019, and we opened a separate investigation into that matter based on our rule, which merely talks about accepting the IRP and really didn't give the commission a lot of room to discuss what was in the IRP. So we opened an investigation in that matter, which gave the commission more latitude to actually talk about it in its decision and actually order some things to be done. But even by simply accepting something for filing, it sends a signal that, I think that this doesn't seem totally out of the realm of prudent behavior, which is the word we would use. And then the next step is the CPCN, which again is, perhaps the next step, as Chairman Case talks about, that signals that there's a better chance of rate recovery for this project. Much of the discussion here today is, focused around the rate recovery, but even the CPCN isn't necessarily, even being granted a CPCN isn't necessarily.
You might say what that is, just remind us.
Certificate of public CPC.
Public convenience and necessity.
Yeah. But anyway, even when you grant the certificate, that doesn't necessarily mean that there's going to be any rate recovery for that particular project. And in today's environment, it certainly doesn't signal how much recovery you might get.
It's all fair enough. Water under the bridge, just full disclosure, the year before, there was a filed integrated resource plan. I wrote to the commission and asked them to open public hearings for public comment on the plan. I was denied, and that's okay. I mean, no, but it's interesting to me that the next time it came up, the commission, I didn't even have to do it. It was other parties, and they did open an investigation.
Mr.
This
Chairman,
says they got
you.
to.
Thank you very much for that.
You're welcome. You're very welcome. And when you guys get your chance, you can address that too. Anybody else for Mr. Burbidge? Oh, Senator Scott, I see your hands up. Sorry. Thank you.
Chairman, I'm going to ask a question from Mr. Burbidge, but I'm also going to serve notice. I want further discussion on the acknowledged issue. I was unable to get in and ask a question earlier because of computer problems, but on the issue of the potential of the rural electrics. My question is, there is in the statute an exemption for the rural electrics that I think came in either with House Bill 200 or one of the Senate files of that same era. Would it be wise to put that particular exemption in this bill to make sure we're not reaching the cooperative utilities, or is that exemption such it wouldn't fit?
Mr. Burbidge, did you get it?
Chairman Case, I think I did.
Okay.
I think that Senator Scott, I think she's suggesting that there should be some specific exemption for the cooperatives. I don't think that the intent of this type of legislation was to wrap all of the cooperatives into the fold of having to file an integrated resource plan. And frankly, if depending on what level of how you delineate who should file and who shouldn't, that would probably take all of the cooperatives out of the fold of having to file an IRP. The cooperative that then you kind of wonder about is Precor. They are rate regulated by us. You could put in language, I suppose, that says only the rate regulated utilities, which would take out all the cooperatives of Precor. So I think I guess I'm suggesting that I'm leaving that up to the committee here to make that decision. But my impression was that the suggestion from the chairman, as far as having this kind of legislation, the intent wasn't to wrap the cooperatives in there, and I hope I'm not misspeaking on that.
Fair enough.
And I hope that I was able to answer Senator Scott's question.
I think we're good. Right, Senator Scott?
Mr. Chairman, I think so. It would take a little while to find it, but I know it's there. And as long as the title would fit it, we could put that in if we decided we needed it at the session.
Yes, fair enough. Thank you. Anybody else? Questions for Mr.
Chairman
Burbidge?
Case, if I
Oh,
could offer,
certainly. Go ahead.
And honestly, if we're concerned about the workload just with the larger utilities and having to take that many integrated resource plans to a full contested case hearing, certainly we don't want to have to do that for every cooperative in the state.
I understand. Senator Barlow.
Thank you, Mr. Chairman. So within the bill, I'll just go to line 6 and 7, page 2, I guess, of the bill. There is file any action plan developed as part of the IRP, et cetera, et cetera. You go to line 12 into 13, it says review and acknowledge an action plan and IRP. So there is no definition of an action plan. So I guess my query for Mr. Burbidge, would you say that IRP stands alone, and then our subsequent action plans, actually the CPCNs and the other things that would follow out as a result of the IRP? Thank you, Mr. Chairman.
Mr. Burbidge. I'm not sure I could answer that.
Chairman Case, Senator Barlow, I'm gonna try. The action plan in an IRP is really, in my experience over the last 12 years of seeing these filed with the commission, is that you got to have a lot of flexibility with the IRP. Things change on an annual basis. For instance, we've seen for coal-fired generation facilities closure dates that change from year to year, to conversions from coal to gas, and these things, and they should be able to change because it's a fluid situation from year to year, and particularly these days, the IRP should be allowed to respond, and I hope this is responsive to the question, should be designed to respond to EPA rules and regulations, which are becoming increasingly important and are controlling the landscape as far as how utilities move into the future. They need to be pretty fluid so that they can then address different policies in the different states, like we were discussing this morning. And those are issues that aren't just limited to the 6 states that are operating, with Rocky Mountain Power, but you've got, multi-state utilities with MDU and Black Hills, and they've got the same issues that all other multi-state utilities would have, including the gas utilities. So, you know, the IRP is a little bit of a different beast. Now, you start seeing the implementation of the plan more clearly as you receive the other applications for certificates, and then of course, you know, for rates, putting it in rates. And maybe I didn't answer that question.
Go ahead.
Thank you, Mr. Chairman. So follow up then. So the way then, with that explanation, then an action plan is actually something that is an amendment to an IRP or an amendment to the planning process that the IRP laid out. Is that accurate? I mean, I'm just trying to understand the sequence of events here because they're both listed in the legislation and they're listed in different ways. One is one responding to the other, and the other two, they're set aside. They're two different entities. So I just want to understand. And I know this is not your language. This came from somewhere else, and we're trying to understand it. But I want to understand what it means in the context of the definition, which is not there, but there is a definition of an IRP. So thank you, Mr. Chairman.
Mr. Burridge.
Chairman Case, I honestly, I don't know as I sit here if I can adequately answer that question.
Thank you. Any other questions for Mr. Burbridge? Thank you very much.
Thank you.
Anybody else like to address this bill? Let's do Mr. Taylor. He's already standing, so I know what he's going to say, and then we'll go to you, Mr. Nelson, then we'll hit over on this side of the room.
Thank you, Mr. Chairman.
We know he's from the agricultural world, and they want an exemption.
Kind of.
Mr.
Chairman,
Moline is next.
Sean Taylor, on behalf of Wyoming's Electric Cooperatives. We've always operated under, ever since House Bill 200 was passed and signed into law, and we were exempt from that. And so whenever we see a section of that being addressed, 37.2, we kind of naturally assume that we're still exempt from anything that falls underneath that. And not to mention with regards to this issue, the cooperatives don't procure any resources. We have our wholesale power contracts, so we don't file those with the PSC. So we assume we're exempt. If you guys want to put another piece of language in there that says we're explicitly or implicitly exempt, we would take it. But I think, like I said, under this section of law 37.2, we just naturally assume that we remain exempt.
I'm pretty sure that's the way this goes.
Okay.
But can I ask you another question? Do electric cooperatives ever negotiate with the GNT about the technology and the type of power, or is it always just take what's on the shelf? I'm just a question. I don't know the
Yeah,
answer.
Mr. Chairman, that's a can of worms. And if you want to get into it, I could probably have,
Not very much. I don't want to get into
Your
it. I know it's an issue with our friends in Colorado.
yeah, it is. And Derek Eisenbraun with High Plains Power could probably come up and speak to that further.
Yeah.
But I think in general, no, they have committees made up of cooperative directors and managers that look at resource procurement on behalf of all the members of like Tri-State.
Mhm.
The 42 members of Tri-State, they have a planning process that they're all involved with. But I wouldn't say individual co-ops negotiate with their wholesale power providers.
Right. And it probably doesn't make sense for some co-ops to have the same power provider and have different mixes of electricity going to different co-ops. That sounds pretty impossible. So,
I think that's right.
so really you can't even do anything about this is what you're saying, other than choose your GNT over time. And that's a very big question.
Yeah, Mr. Chairman, we're going through a lot of that right now. And like I said, Mr. Eisenbraun could come up here and probably talk about it for a few hours, which I know you don't want to get into on that, but
I like him a lot, but I don't want a few hours of it.
he'll be up here later.
Okay, good.
Okay.
Do you have a question on this?
Thank you, Mr. Chairman. So I guess I would, and it doesn't have to be now, I can shoot an email, where you think that exemption is in statute that would take rural electric out of potentially falling under this bill. Thank you, Mr. Chairman.
Thank you.
Mr.
Yeah, I
Chairman,
think we'd all like
we'll
to.
definitely shoot that to you.
Anybody else for Mr. Taylor? Thank you, Mr. Taylor.
Thanks.
Mr. Nelson. It's good to see your front side, sir.
I'm sorely tempted to have to explain that to everybody else.
I have sat behind Mr. Nelson all day long. Anyway, go ahead.
Thank you, Mr. Chairman, members of the committee. My name is Thor Nelson. I am an attorney with the law firm of Holland and Hart, and I represent the Wyoming industrial energy consumers. For those who are not familiar, the WIAC, as we sort of refer to ourselves, is a coalition of large electric users in the state of Wyoming. We have 20 members who are different companies in a wide variety of different sectors in the state. There are oil and gas companies, trona mines, chemical plants, manufacturing facilities, cement plants, a wide variety of different folks who share the commonality that they consume lots of electricity. And so we work with them to try to keep electric rates as reasonable and affordable as possible, including, as my colleagues are doing as we speak, intervening in public utility rate cases over at the commission. We are very grateful to the committee for taking up this bill, as well as the others that we will be discussing this afternoon, because we think that these are important questions for the state of Wyoming. So, talking just a little bit about the legislation on the IRP, let me just level set maybe a couple of things and then maybe answer, if I can, expand on the questions that have been raised so far. So, building on what Chairman Case mentioned, integrated resource planning is a process that the electric industry has been using for a long time to think about how it is that long-term needs should be met. Just to do a little bit of a history piece, if you're interested, this all arose back in the 80s when it became popular to consider a mix of both demand-side resources, meaning energy efficiency, along with supply-side resources, meaning new generation. And so the idea is you want to integrate the planning of both supply and demand side resources. And so these sorts of things became popular. A little bit later on in time, it became even more important because the question became, as we looked into now this century, we had a lot more variety and options in terms of generation types. Renewable generation became more popular and to be considered. And so integrated resource planning developed and expanded its scope to talk about how it is that the utilities should go about meeting future electric needs and the right mix of generation resources in conjunction with, as was discussed, transmission resources. Now, different states have taken different approaches to this idea. Some states, and Oregon and Utah are one of them, or two of them. Some states have taken what I will call a more proactive approach, where the state commissions, either through law or through rules, have directed the electric utilities to make these filings and have had active investigations about these filings and taken an active role in talking to the electric utilities about how the regulators thought about the right mix of generation resources. Other states, like Wyoming, has taken a more hands-off approach traditionally, where, for example, in Wyoming, the current rule is if you file an IRP somewhere else, send us a copy, essentially is how it works. But as we, WIAC, have tried over the past several cycles to get the Wyoming Commission excited about taking a more active investigatory role into these processes, that has come to no avail. And the commission has said, look, we're not interested in doing that unless we are directed to do so by the legislature, and we will simply have these filings here, then they'll sit on a shelf, and we will then see what happens going forward. So we think that's the wrong idea. We think that rather it would behoove Wyoming to take a more active role when decisions are getting made about resource planning to make sure that the interests of Wyoming customers, in particular, interests in ensuring reliable electric supply through a reasonable application of fossil fuel-fired resources, continues to the benefit of Wyoming customers. And so that's really the point of this. Now, I want to answer a couple of questions because I think that will help further elaborate on what the ideas of these things are. Start with the question of to whom this legislation should apply. I think that's a good and a fair question. I will say that from WIAC's perspective, we certainly would have no objection to exempting out the rural electric cooperatives. As Mr. Taylor correctly points out, these issues are decided by the more federally regulated generation and transmission companies like Tri-State and Basin Electric. And so really the Wyoming Commission is the wrong forum to deal with those sorts of questions. And so exempting the rural cooperatives would make sense. I will say I've taken a look at the statute that Mr. Taylor's referring to. I don't think it's very clear that they would be exempted from this bill. So I would encourage the committee to consider an amendment to the bill if it moves forward, adding an exemption. And you have two options here. Option one is you can exempt those entities who are exempt from rate regulation under 37-17-102. That would exempt all cooperatives save Precor. I'm not sure there's a whole lot of point in having Precor subject to this bill, but that's an option.
Yeah.
The other option, which might be more clear, is to simply exempt all electric cooperative companies. That term is defined in statute at 37-17-101(1). That would include Precor and all of the other cooperatives. And I think if that was the committee's intent, clearly carve them out of this bill. Now, the second question onto applicability was, should it apply to all of the investor-owned electric utilities that operate in Wyoming or just some of them? There are three: Rocky Mountain Power, Pacificor, Black Hills here in Cheyenne, Cheyenne Light, and Montana Dakota Utilities, or MDU. So from my perspective, the most important one is Pacificor. And the reason that's the most important is Pacificor is currently operating under the direction of utility commissions in the West Coast who have, I think it's fair to say, a very different perspective about how electric resource planning should be done than folks here in Wyoming. And so they are already being told by their regulators on the West Coast, we want you to go 100% renewable. And so having Wyoming engage in that process is very important. Now, conversely, if you look just at the reality of Black Hills and MDU, where they operate and the commissions that exist where they serve, this really isn't an issue. I mean, it's not nearly the same sort of question, because in the other states that those two utilities operate in, they're pretty similar in mindset in terms of how electric generation ought to occur. And so the imperative, I would say, for applying this law to those two companies is substantially less, maybe even close to non-existent. And so to the extent, in particular, you are concerned about things like the Wyoming Commission's level of resources, might be perfectly reasonable to exempt both Black Hills and MDU from this process, although obviously that affects a bunch of Wyoming customers who do have an interest in this, but probably not to the same extent. If you want to do an exemption based on a customer count, here's where that stands. So based on information we've been able to identify, Rocky Mountain Power reports that they have about 150,000 customers in the state of Wyoming. So if you want to tie them in, you got to have some number below 150. Black Hills reports they have about 44,000 customers in the state of Wyoming. MDU has just under 17,000. So that's the range of numbers you can pick from if you want to be more surgical about where the law would apply or not apply. All right. I want to move then to another question that was, what does it mean to have an action plan? And this is an important discussion because I think it helps clarify what integrated resource planning is. So when utilities do integrated resource planning, and this is very common in all the IRPs, I do this work in a bunch of different states in the Rocky Mountain West, and they're all pretty much the same. IRPs, generally speaking, are done with a 20-year plan by and large. Sometimes you see folks who have 30s, but mostly it's a 20-year planning horizon. But within that 20-year planning horizon, what is ordinarily done is that there is what is called a 5-year action plan. Now, it's all part of the same IRP, but the stuff in the first 5 years is more real. And it's more real because we have a better idea of what is going to be needed inside of 5 years. Once you get past that 5-year mark, lots of things can change. Loads change, generation options change. And so the way these IRPs are filed, the reason they call it an action plan is because that's the stuff that really is likely to happen. And then years 6 to 15 or 6 to 20, that's the stuff which we think is going to happen, but we'll get more surety about that in a future IRP 2 or 3 years down the road, depending upon the particular cycle in a particular state. Some states are 2 years, some states are every 3 years. So that's the difference. So the action plan is part of the IRP, but it's just those first couple of years which are more real. And so we've given them a name in the industry, and that's the name that we've given them. Another question was raised about what does it mean to acknowledge, and what exactly does acknowledgement versus acceptance mean, and how does that play a role? And I think the easiest way to talk about that is to give you an example. So in Utah, following Rocky Mountain Power's discussion of the need to accelerate the retirement of a bunch of coal facilities, going back now a few years to 2019, in the IRP that PacifiCorp filed in Utah following that, the Utah Commission said, we don't acknowledge that. And so Utah did an investigation, they thought about this, and they said, we have real questions and concerns about whether those accelerated coal retirements are really the right course of action. Now, none of the things that were at issue were in that 5-year action plan. And so that lack of acknowledgement didn't have really an immediate effect. But what it did was it sent a very strong signal that the Utah community, which is PacifiCorp's largest state, has some serious questions about how these coal retirements ought to be done and how that ought to be treated. And so in subsequent IRPs, PacifiCorp then went out of its way to try to explain sort of what that meant and why that was right. And so they did more analysis and more explanation to try to get Utah comfortable with what their plans were. And that's still a work in progress, but that's the point of the acknowledgement. It's not saying absolutely do this or absolutely don't do this, but it sends the signal as a regulator, we have real questions and you need to do a better job explaining what you're doing before we get comfortable with that. Now, relative to WIAC, the issue that we see in the most recent IRP that PacifiCorp has filed, and we've submitted comments on this to the commission, but those comments are unlikely to go anywhere other than into the file, is when we looked at the most recent IRP from PacifiCorp, we think that PacifiCorp, to use our perspective, put their finger on the scale and prevented new gas resources from really being carefully considered as a resource option. And the reason we think PacifiCorp did that is not rocket science. They have a bunch of states on the West Coast who have declared they don't want any more fossil fuel resources. But from WIAC's perspective, we have a real concern that there needs to be a portion of the portfolio that continues to maintain reliable and dispatchable power. And we think that the analysis was not done in a way that fairly weighed or considered the benefits that a fossil fuel resource might have. And so what we encourage the commission to do is to try to investigate that. But again, because of the way the process works and those IRPs just, sort of sit on a shelf, there really isn't a way to dig into that further. And there really isn't a way for the Wyoming Commission to consider our perspective and decide whether they agree with that or not, and send a more clear signal to Rocky Mountain Power about what they think about the needs of potential additional fossil fuel resources to maintain reliability. So that's the point of this, and that's what the acknowledgement does, and that's how Utah used it in the past and the effect that it had. Now, as Mr. Burbridge explained, the rubber really hits the road when you get to the CPCN process, where specific projects are officially approved. But in the electric industry, you have to plan for that years in advance. And so the later you wait before you tell the utility, I really would like you to go a different direction, the harder it is to move that ship a different direction. And so we think that for Wyoming, it would be better to get in early, make sure we're happy with the plan, or at least let PacifiCorp know if we're unhappy with the plan, so that that can help steer the direction of the resource future in a way that makes sense for Wyoming customers. So that's why we support this legislation, and I hope that helps answer the questions that have been raised, and happy to answer any other questions the committee may have. Thank you.
Do we have any questions for Mr. Nelson? Senator Scott, I see you. Let's go to you first.
Mr. Chairman, and it really isn't what he was talking about acknowledgement, that sort of thing. My question for him, that seems to be a key in this bill. If you look at page 2, it says the rule shall, and then double I there is require the commission in determining whether the action plan and an integrated resource plan should be acknowledged. Should we say instead of acknowledged? My two questions about that. One, is there any statutory definition that you're aware of what acknowledgement means? And second, should we say instead of acknowledged, should we say approved, so that you would have the commission having an authority to disapprove the plan? Would that be a better way to word that, one that would be more understandable generally?
Okay, Mr. Nelson.
Thank you, Mr. Chairman, Senator Scott. So it's an interesting question. So I suppose is the three A's are your options. You have approval, acknowledgement, and acceptance. And if you look at the IRP rules around the country and the statutes around the country, those are the three different words that get used. Acceptance is what we currently have in Wyoming relative to IRPs, and that's simply, I see you filed it, I accept that filing, and it goes into the records. Approval is a more strict standard. The hard part, and I think the reason why the statute in Utah, as well as a similar statute in Oregon, don't go as far as approval, is the IRP is a long-term document. And you don't really want to lock in what's going to happen, even necessarily out 5 years into the future. I think it's good for the utilities and it's good for customers to maintain what I'll call some sort of operational flexibility, if you would. And so from my perspective, as I've seen the Utah Commission use the power of acknowledgement, I think it does do the job of sending the message to the utility of what that regulator thinks makes sense going forward. I've seen the utility actively respond to that signal. And so I think that that is a good thing. Approval would be stronger, of course, but it's very hard to approve stuff that far into the future without then saying, wait a second, I need to take that back because 3 years later, some change has occurred and you no longer want to go down that path. So that's why that balance has been struck historically. And from my perspective, Senator Scott, I think acknowledgement is the right way to find a balance, at least at the starting point, to see if this makes sense. Because from a practical perspective, if I'll use this analogy, maybe Wyoming can walk before we run, but I would like us to at least walk instead of standing still.
Senator Scott, your hand's still up. Do you have a
Yep.
follow-up?
Yeah, Mr. Chairman, following up on that, whichever word we use, I thought you made a very good point earlier that the stuff in the first 5 years of the plan is much more relevant, much more certain than the stuff later on. And that's, I think, fairly obvious. Should we, in this statute, explicitly have a two-stage thing where we can do different things regarding the first 5 years of it than we do regarding the longer term stuff?
Mr. Nelson.
Mr. Chairman, Senator Scott, I think that's absolutely an option. Again, you can parse this any way that makes sense to the committee. Certainly, if you want to go beyond acknowledgement to an approval, focusing that only on that 5-year action plan would make sense because stuff beyond that really is very speculative. But I will tell you, just for what it's worth, that 5-year action plan, and I'm just going to rough justice this, I think it's probably 85, 90% accurate, but it's not 100%. And so I'm just a little bit leery about making more work for the commission than is necessary, because if you approve it and then it does turn out that you want to do it differently, they got to come back and do it differently. And so that's something to be considered in the balancing of this equation. But I agree with you that focusing on that early years is definitely the place where you want to focus your attention, because when you get to these processes in Oregon and Utah, that's where they do in fact focuses on that action plan. And I apologize, Senator, I had one language change that I forgot to mention in my comments. Can I
Go ahead.
mention that real quick? I had just one little thing that I would encourage the committee to think about from a drafting perspective if you elect to forward this legislation. And it's on page 4 of the bill. There's a section there on line 25 in Roman 2. It says a brief description and summary, cost benefit analysis, if available, of each option that was considered. We would encourage the committee to delete the word brief and if available. We think that that really is a critical part of the IRP, that is an understanding of the analysis of the cost and benefits of the different options that were considered. And so we would recommend that that be a clear requirement So that, for example, if the evaluation considered adding a new natural gas-fired resource but rejected that, that the analysis about that was very clearly provided. So that would be one language change we would suggest, but otherwise really appreciate the work that LSO did in drafting this.
Okay, just Representative Yen.
Mr. Chairman, thank you. So this is more of a philosophical question on whether we should delegate this responsibility to the PSC at all. The PSC is a group of unelected officials, and it does feel like that we're delegating a power to let them make somewhat of a policy decision on the PSC level. And I do worry that if we start down that road of giving them policy decisions to make, that at some point we're not going to trust them if they make a policy decision that we don't like, and then that would further erode the trust in them making decisions when it comes to decisions that don't revolve around making policy decisions. Does that make sense? Thank you,
Mr.
Chairman.
Nelson, does that make sense?
Mr. Chairman, Representative, so I think that this body has delegated to the commission a number of important tasks here recently in particular. One thing that you've delegated to the commission in recent legislation is a requirement that they create a reliability standard relative to the state of Wyoming. And I think that, in fairness, I think this IRP dovetails very nicely with what the legislature did in asking the commission to consider and apply a specific standard for utilities to ensure that the resources are sufficiently reliable. So in that context, I think that this is a reasonable policy decision to delegate. The other thing which I will mention, and this is an important consideration, in these IRPs, one of the big questions relates to information which oftentimes is competitively sensitive and confidential, specifically as it relates to forecasts of fuel prices into the future, coal and gas and things of that nature. And while obviously public access and engagement is important, there are a number of really important considerations in this process that can only be effectively done in a place like the commission, where they have the tools in place to ensure that confidentiality so that the issues can actually be fully vetted without impeding the competitive marketplace. And so I can certainly appreciate that concern, but I think in this instance, the commission is the right place to do that. And if I were sitting in your shoes, I think what I would do is, as you go through the process of meeting with the commission, as you go through your sessions and they come before you, I think ask them questions about what they're doing and how they're approaching this. And obviously, if down the road you figure or you decide that they're not doing the job you want, this legislation can be changed. But I think for the first instance, that's the right agency to do this job because of the reasons I've expressed.
Anybody else? Senator Barlow.
Thank you, Mr. Chairman. So picking up on that confidentiality aspect of some of the I guess proprietary information or pricing or whatever, in Utah, and maybe you practice in Utah as well, do their rules, commission's rules for contested cases, because that's what this language says, do their rules account for that confidentiality? Can they protect that company's information when it's necessary? Because this looks to me like contested case is a public proceeding. So, but can they protect that information? Thank you, Mr. Chairman.
Mr. Nelson.
Mr. Chairman, Senator, yes, absolutely. In Utah and in Wyoming, and in fact, all the commissions I appear, they all have procedures to have confidential information submitted, be considered in closed sessions. Every commission I work in front of, including Wyoming, tries to minimize that so that the public has as much access as possible. But Utah and Wyoming all have a process to permit confidential information to be submitted and considered as necessary for the commission to do its job.
And just to tag on, a party to the proceeding, if admitted by the commission, can also receive the ability to look at the confidential information. Anybody else? Mr. Nelson, back to your proposed amendment on page 4, bottom of the page, the cost benefit analysis. Current language is a brief description and summary cost benefit analysis, if available, of each option that was considered. And we're not going to do the amendment now, but I think you're saying you eliminate the word brief. So would you leave the word summary? So you would, Go ahead. You would leave the word summary? We can work together.
Yeah, so, sorry, Mr. Chairman. I think the word summary is fine.
Okay.
Because it then couples with the language at the end where it says any other data and analyses the commission may require, so they can augment that. But I think the key thing to avoid is the brief, because I'm not sure that's helpful, but mostly the if available.
Available.
The if available is the most challenging part, because you don't want to give the utilities the option not to have done that analysis and make it available.
So it'd be a brief description, or I'm sorry, a description and summary cost benefit analysis of each option that was considered.
Yes,
When we
Mr.
get to the appropriate time. Thank you. Any other questions for Mr. Nelson? Thanks. Stay close. I guess you're going to be here all afternoon.
Yes, thank you.
All right. Who would like to go next? Mr. Garlish, welcome. You're earning your money today.
Richard Garlish, Rocky Mountain Power. So that was a lot, and I agree with most of it. So I'm just going to talk from a practical perspective and then answer any questions. We do this in Utah. We do it in Oregon. Happy to do it in Wyoming. I mean, our biggest concern is how that lines up with, the workload and the analysis, because it is a lot of work to go through the contested case proceeding, provide the discovery. And the IRP is a highly technical document. I mean, I do kind of quibble a little bit with the characterization that goes on the shelf, and this is just one of those places where reasonable minds can differ. But the IRP is functionally and practically, an ongoing, never-ending process. I mean, it's a 20-year planning horizon. It has to be done every 2 years. So by the time you've finished the 2-year process, you're starting again. And even in that 5-year action plan period, things change significantly. Like you might make an assumption, for example, on the ozone transport rule and its effect on the availability of thermal units and project that over 20 years, a conservative assumption that it's going to pass in law, but then win a stay that exempts it, or have a SIP accepted in Wyoming that exempts that from your 5-year look and 20-year look. So it is an ongoing thing. It happens a lot. But I would also concede that, there is a proactive approach, and other states have chosen to use that. And Wyoming can certainly do that here. I guess my biggest thing on behalf of my regulatory group is making sure that it aligns with Utah and Oregon so we can manage the work process, and just note that it's a lot of work for the commission. Contested cases are a lot of work, a lot of discovery, a lot of analysis. But it's all part of the process. To Senator Case, your previous point, as a regulated utility, like everything we do is subject to review by everybody. And we follow the rules, because at the end of the day, we're just trying to produce our receipts for the money that we've spent to show that we did it prudently, we did it on behalf of customers, we did it in their best interest. That includes planning for it, that includes acquiring it, that includes the money, and then maintaining it. So we don't have a problem with this bill. So I'll just shut up at that.
Thank you, Mr. Garlish. Questions for Mr. Garlish? Do you kind of agree with the, you got the plan, and then you got what was the other term? The 5-year term?
The action plan?
Action plan, yeah.
Yeah, I'm gonna respond. I think that the way that you characterize it, like, one way to think about it is, we provide the information to the people that run our business as a regulated utility, right? We have to get a ruling that whatever we did was prudent and in the interest of our customers. So the way these mechanisms, they don't all exist in a vacuum by themselves. They do relate to each other. The IRP is focused out on that 20-year look. What is the least cost, least risk way to serve customers based on what we know today? And then we overlay a bunch of different scenarios. Well, how does that least cost, least risk portfolio change if you assume OTR, or if you assume no recovery of thermal in Oregon, and you assume no recovery of renewables in Wyoming, and then you run a bunch of different scenarios to come up with what is the least cost, least risk based over 20 years. And then I agree with Mr. Nilsson and Mr. Burbridge that 5-year period, like more is basically known. But as you move into that 5-year period, more is known, but there's still not a lot not known. So we know a little bit more. Now we move into the time of, now we need to get a certificate of public need and necessity. So the ante, if you will, or what we have to show that we're being prudent increases, because we know more, we have a a better idea of how we're going to serve that load, be more accountable on it. And then the next step being the rate recovery of it was where really rubber meets the road. Like, you had a plan. Did you act on it? Was it prudent? Can you show me the receipts for all the money you spent and that you did it prudently? And was it a good decision? So, there's scrutiny at every single step along the way, in every single state. And so this is not controversial or new to us. We just think it's part of doing the business as a regulated utility. So.
Thank you. Any questions? Anybody else? Thank you, sir.
Yep.
Who else would like to address Mr. Bush? Mr. 44,000 customers.
Funny you bring that up, Mr. Chairman. David Bush with Black Hills Energy, and knowing that the company Christmas party is coming up soon, I feel like I should hop up here and actually say thank you to Mr. Nelson. And if you all are willing to exempt us, my regulatory and legal team would be super excited about that, and I might get a really nice present at that company Christmas party. So beyond that, though, I think the same for us. It does add another level of workload, and it increases the amount of burden that we have to deal with. But to not go too much over what Mr. Garlish said, it really is just more paperwork. So the process is already in place for us with the IRP, the CPCN, all of that, where these plans are scrutinized to a level that we feel is already appropriate. But again, understanding the climate and where we are these days, we really don't have too much of an objection. I don't, as the government affairs guy. My legal and regulatory team, I don't know if they're super excited about it, but.
You probably better tell them. I mean, let's just keep this a secret, but I think you should tell them.
Yeah, that was their comment, was this is more paperwork, and yeah, so attorneys, they love paperwork and billable hours and things like that. So
This sounds like the Education Committee. Anyway, any questions for Mr. Bush? Thank you very much, Mr. Bush.
thank you, Mr. Chairman.
Anybody else wish to address this? We got anybody online? Got one online. Let's go to the online. Ms. Anderson.
Yeah, thank you, Mr. Chairman. Shannon Anderson on behalf of Powder River Basin Resource Council. And our organization does participate in the integrated resource planning processes for our 3 rate regulated utilities. We're involved in both the stakeholder process for Rocky Mountain Power and the process before the commission. We've also participated and submitted comments on the Black Hills Cheyenne Light IRPs and MDU's IRP. Up until this last one, MDU actually didn't include the Sheridan area in its IRP. It included the other parts of its service territory that are separated out from the Sheridan area. But most recently, they did submit an IRP that was unique to the Sheridan service area. And we appreciated the opportunity to be involved in that. We would just remind the committee that, of course, statutes have to be generally applicable, and that you shouldn't kind of single out one utility. And with that, I think that you should have the statute apply to all of the 3 rate regulated utilities. If you want to exempt the rural electric cooperatives, that's okay. But I would note as well that Tri-State does file, it's not an IRP, it's an ERP, an electric resource plan with the state of Colorado. And the Colorado Public Utility Commission does have quite a bit of review authority over that ERP. So if Wyoming would want similar review authority over the Tri-State plan, you might want to think how to bring that into this bill as well. But for the most part, we support the bill. We appreciate WIAC bringing it forward to you. We've supported similar concepts in the past from the good chairman. We've supported rulemaking that WIAC has proposed before the commission. So it's a good time to take this on, and we appreciate the effort of the committee to move it forward. Thank you.
Thank you, Ms. Anderson. Any questions for Ms. Anderson? Thank you very much. Anybody else on public comment? Anybody looking around? Nothing? Committee, we've had, heard the public comment. What's your pleasure? Got a motion by Barlow. Is there a second? Second by, is that Chadwick? Okay. Discussion. Representative Knapp,
Mr. Chairman, I would offer an amendment.
go ahead.
And I think rather than an exemption, I'm going to use the approach of using the term regulated power or regulated public utilities.
Just before you offer it, I kind of disagree with the idea that they're not rate regulated. They're under rate regulation, and Mr. Taylor might disagree with me here, if their customers ask for review. So that doesn't really excuse you entirely from rate regulation. So I'm anticipating your motion, and it might be better to go with the second approach, but
Of an exemption.
yeah, sorry about that. But
Just hate exemptions.
And Mr. Taylor just went like that. We can agree. But that would be to exempt the rural electric co-ops, right?
Yes. I'm not sure where we would put that in.
Let's get a second and we'll figure it out.
Second.
Got a second by Barlow. Barlow.
Thank you, Mr. Chairman. So I think we can just go to page 3, line 17 through 19. And I'm sure staff can, this is the affected public utility definition. And then just comma, this shall not include cooperatives as defined by. I don't know if that's the simplest way to do it, but that puts it all in one place. We don't have an exemption somewhere else in the statute. It's actually in the definition, potentially.
And quickly, is that the 37-17-102? 101. Okay, 101-1. So it'd be 37-17-101, Romanet 1.
So
You guys see it? The staff kind of verify that that's. Getting close?
So, Mr. Chairman, 3717-101A1 is the definition of cooperative electric utility.
Okay, good. Senator Barlow.
So thank you, Mr. Chairman. So I think with Representative Knapp's, we give our staff a little latitude to place it into this C, Romanet I, in there. That doesn't answer the question about the broader, is it one utility, 3 utilities, or the other part of it? This is just the exemption within that. And I think that's what the representative was trying to get to. All right, thank you, Mr. Chairman.
So as I understand the amendment, it's just for the rural electric cooperatives. Yeah, exempting them from this requirement. Further discussion? All those in favor signify by saying aye. Any opposed? Okay. If we wanted to take up Ms. Anderson's proposal about at the GNT level, generation and transmission level, somebody can work that up if they wish to. I'm just saying that would be separate. Senator Scott, you have your hand up, and then we're going to go to Representative Ottman.
Mr. Chairman, I've got a question for Josh Anderson as our drafting attorney. It seems to me that this business of the word acknowledged or acknowledgement is a key to this bill. And I've got 2 questions relating to that. First one is, what do you think as our drafting attorney it means? You've heard the discussion today. What do you think it means if we don't change anything and we simply pass the law as it is, as the bill as it is right now? And second, my reading of the title is that we could use different language on this issue without having to worry about being consistent with the title. I think we would be. Is that an accurate reading?
Okay, let's get to Mr. Anderson on that.
So, Mr. Chairman, and as was noted earlier, I think
You might pull that mic a little bit closer.
Mr. Chairman, I think my understanding of what acknowledgement is, you know, as was noted earlier, something, you know, less than an approval, but more formal than accepting it. And I think that the bill, you know, as written, would give the commission some ability to further, you know, define that process in their rules, and does require them to adopt rules under this bill. And I think I missed the second part of the question, Mr. Chairman.
Senator Scott, second part of the question again?
Mr. Chairman, if during session we decide to say not acknowledged, but approved, or say, use some other language there that we could define, so it would be something short of approval, we wouldn't be violating the title, would we, if we did that?
The title just says review, an act relating to public utilities providing for the review of integrated resource plan action plans by the Public Service Commission and providing rulemaking authority. That seems fairly broad to me.
I would agree, Mr. Chairman.
Agreement by Anderson.
Okay.
Back to you, Senator Scott.
Yeah, so review wouldn't preclude us from telling them what to do if their review was unfavorable.
I think it doesn't limit. And I think if we had to further define review in the bill in the middle of a session, because we were worried about title issues, we could define that review to mean anything we want. So I think it's a good fishing license. Fair enough? Anything else? Representative Ottman, I'm sorry, I did say you'd be next.
Thank you, Mr. Chairman. Mr. Nelson had mentioned on page 4, line 25 through 27, and to amend out the word brief and also the words if available.
Got it. Is there a second? Got a second by Newman. Discussion, that would include the grammatical corrections with the commas. Any discussion? All those in favor signify by saying aye. Aye. Opposed, no. That's carried. Thank you, Representative Ottman. Senator Scott, your hand's up? You mean that? Well, you're on mute, sir. You were, or you?
I was wanting to divide the motion because I think we ought to leave the brief in.
I'm sorry, I didn't catch you before. Why don't you just make a separate amendment to put brief back in? It's kind of out of order, but.
Okay, Mr. Chairman, I'll do that. I think we want to keep this under some kind of control as to how much we're asking. I think we ought to ask for what they've got, but.
Okay. Anybody want to second this? Let me ask, I'm taking a timeout. Mr. Nelson, would that really kill you if it still says brief? Come on. Yeah, so does anybody want to offer a second to Senator Scott's brief amendment? Not getting a second, Senator Scott. No reason we can't put it in later.
Yeah, okay.
Okay, back on the bill. Yes, sir, Representative Ottman. Yes, ma'am.
Thank you, Mr. Chairman. Okay, I had made a note, and I'm not sure if it goes along with what you just talked about with the exemption, but to have a number in there for the amount. Like we had talked about, Rocky Mountain Power has 150,000 customers, Black Hills 44, and MDU 17. So did we want a minimum number in there or anything instead of that 200,000, or was that just a note?
Yeah, that's a note. The question is, do we want it to apply to all these utilities, or do we want to just catch our friends that are the big fish? So I leave it to the committee. I think
We
it,
can mix it, we can forget that.
well, right now it would apply to everybody, right? Oh, with 200,000
There's
doesn't
an
apply to
X.
anybody. It might someday. So,
Mr. Chairman,
yeah, Representative Wiley.
Representative Ottman, if you would want to include all three, I would do a second on that.
And so the
Okay.
second would drop the number to greater than 15,000, or what does it do?
17.
How would you do it operationally? Mr. Nelson, you may.
On page
But-
three,
Well, could you come to the microphone though, at least? Yeah.
Thank you, Mr. Chairman. If you look at page 3, line 18 of the bill, if you want to do what Representative Ottman and Representative Wiley have suggested, what I would recommend is you delete the word starting with, and delete the rest of that line in line 19. So it just says affected electric utility means a public utility. And then going back to the earlier language, you'll be adding other than an rural electric cooperative.
Okay.
And if you wanted to exclude somebody, you would leave that language and then replace the X with a number.
Gotcha. Thank you very much.
Thank you.
Which way do we want to go? If you want to catch everybody, that's probably a great suggestion there. It makes for an odd-looking sentence here, but we have a further discussion behind it. Representative Knapp.
Yeah, Mr. Chairman, thank you. I would, as a matter of consistency with what we're requiring from utilities, I would actually leave that out
So,
with the limit.
so you would not have a limit.
I would have.
People agree with that? So that's a motion. That is the motion to essentially say affected electric utility means a public utility,
Period.
semicolon, and then the rest of the paragraph. Because the next sentence exempts the co-ops. Is there a second? Second by Haroldson. Discussion. All those in favor signify by saying aye.
Aye.
Any opposed?
Did you take my amendment?
Okay, Mr. Bush is not going to get his Christmas party thing. Anything else on the bill? Anything else on the bill? Are you ready for the question? Call the roll, please.
Mr. Chairman, roll call for 24 LSO 0273, Public Service Commission Integrated Resource Plans as amended. Senator Barlow,
Excused. Oh, wait, he left aye as amended. I have it right here.
Senator Barlow, aye. Senator Boner? Aye. Senator Landon, excused. Senator Scott?
Aye.
Can you repeat?
Aye.
Thank you. Representative Chadwick? Aye. Representative Haroldson?
Aye.
Representative Harshman?
Excused.
Representative Knapp?
Aye.
Representative Newsom? Aye. Representative Ottman?
Aye.
Representative Wiley? Aye. Representative Yin?
No.
Co-Chairman Case?
Aye.
Chairman Olson, excused. 10 aye, 1 no, 3 excused. 3 excused.
Thank you, Katie. If there's any heartburn about accepting the proxy from Senator Barlow, I feel that he was here for 99% of the discussion and he got called away unexpectedly. He'll be back shortly. So, all right, the next, we got more bills? The next bill for our consideration is 24 LSO 0274, Working Draft 3, Public Utilities Net Power Cost Sharing Ratio. I bet this is a real easy one. Mr. Anderson.
Thank you, Mr. Chairman. Josh Anderson, LSO. Again, yeah, this is the next bill that was requested at the end of our last meeting. It just goes into 37.2.121, which related to non-traditional rate making. Adds a new sentence at the end of that on the bottom of page 3. It just says, if the commission approves any form of cost tracking mechanism for a public utility to recover changes in electricity supply costs between rate cases, The mechanism shall provide for a sharing of those costs where customers are responsible for not more than 70% of any cost increases, and the public utility is responsible for not less than 30% of any cost increases.
Thank you, Mr. Anderson. Questions for Mr. Anderson? And I guarantee he's probably not the right guy to ask about what all that means. And he'll appreciate that. So thank you, Mr. Anderson. Mr. Burbridge, you want to start? And I don't know how you preface this. This is an integral argument about the case that's happening.
Thank you,
Mr.
Mr.
Burbridge.
Chairman. Two things to point out about this bill. Number one, to try to set a cost-sharing ratio or cost-sharing band by statute is a terribly difficult thing to do. It really is a utility by utility, and we're talking about vertically integrated utilities here situation. For instance, Black Hills sharing band is more of a 95.5% affair, and it's different for MDU, and of course everybody knows what's going on with Rocky Mountain Powers by this time, but perhaps
I'm not sure they do, but I'm not sure you're the right guy to explain it.
Well,
Yeah, we'll let Mr. Carlos explain it.
I will leave maybe some of the more details on this to the company representative, but essentially what it is doing is trying to hold the company more accountable. Currently Rocky Mountain Power is at 80/20, and it generally is an ECAM issue. As a matter of fact, it is the ECAM issue. The company does in fact address this issue in the rate case to try to change what that sharing band might be, which is going on currently. And I'm not going to discuss more of that, for the obvious reasons that I discussed this morning. But it is to incentivize the company to, in my opinion, make more prudent investment decisions, particularly with net power costs. And it is with the net power costs as far as the purchase of power on the market and what have you, and gas and coal. So, but the bigger issue is more likely that we think that this particular draft legislation might present a takings issue, and so we're concerned that it's got that problem right out of the chute. And those would be the only two real comments I have about the draft legislation at this point in time.
Thank you. Thank you very much. Questions? Any questions for Mr. Burbridge? Go ahead. Representative Newsom.
You. Can you describe what would constitute a takings? How that would look, what that looks like in this context?
Chairman Case, Representative Newsom, I believe that it's not providing due process because it would force costs of what might otherwise be ordinary business expenses through legislation just to prevent a utility from being able to recover prudent business expenses, then does not give them any administrative or any process to be able to contest what that ratio might be set, short of just at this point contesting the statute itself. So it really is potentially taking what would be recoverable by a utility as a prudent business expense by just taking that away from the utility, frankly, in terms of cash, without any review by court. And if I,
Go ahead.
I'm certain that there's some folks in this room that can give a more detailed explanation.
Probably on both sides.
Yes.
Any other questions for Mr. Burbridge? Senator Scott.
Mr. Chairman, let me say, I think I agree with Mr. Burbridge on this one. And my question for him is, if we added to the title a phrase saying providing exceptions, and then provided an exception back in the text of the bill where they could prove that they had adopted the most reasonable or resource allocations to, and couldn't provide another, would that sort of thing then remove the takings or ameliorate the takings issue?
Mr. Burbridge, if you wish.
Thank you, Mr. Chairman. Senator Scott, I would have to give that some more thought. I don't know. It might help, but I hesitate to fully answer that question at this point in time because
It's sort of like you're asking the general counsel of the commission to speculate on something that he might have to really give advice to the commission on someday. And it'd be pretty bad if he said, well, that was my idea.
I just hesitate to
Yeah.
try to, tackle that question today.
We can look at it, Senator Scott. We always look at your ideas. Anybody else from Mr. Burbridge? Representative Wiley.
Mr. Burbidge, excuse me. This ratio of 70-30 has been used in statute previously, correct?
Mr. Burbridge.
Mr. Chairman, Representative Wiley, I'm not aware that this ratio has ever been used in statute before.
It has been policy before. It was the previous relationship before the last rate case, is my understanding. I'm not sure of the timing, but it was 70-30, and it went to 80-20. And now the company, they'll be addressing us, but they're proposing it to go away completely. So it'd be 100%. Anybody else? Thank you, Mr. Burbridge. Stay close. Should we let the company go first? Come on, where's your fairness? Oh, the company says, go ahead. Wyack, come on. Mr. Nelson.
Thank you, Mr. Chairman.
Mr. Nelson.
Okay. I think it might be helpful to provide a little bit of background here to the committee relative to this particular piece of legislation. So we're going to do just a little bit of history. This all started, I suppose it's fair to say, following, for those who have sort of longer memories, the California power crisis in 2001. During the California power crisis, for those who, like I said, who were around and paying attention at that point in time, Rocky Mountain Power experienced a dramatic increase in the price of electricity. That dramatic increase in the price of electricity was compounded because during the middle of the California power crisis, one of their large coal-fired power plants in Utah experienced a massive failure, the Hunter power plant, causing them to need to go into the market to acquire a large amount of power. That was very expensive. So Rocky Mountain Power brought a filing to the Wyoming Commission asking for authority to recover approximately $90 million in higher power costs that they incurred during the crisis. The Wyoming Commission said, you can't have any of it. It was actually quite a remarkable decision. And the basis that the Wyoming Commission relied on was that up until that point in time, and this is now 2001, so for decades prior, the rule was that you set rates in rate cases, and in between rate cases, the company is at risk of cost increases and is the beneficiary of any cost decreases. That was the traditional regulatory paradigm. The commission said, that's the way it works, and you, Rocky Mountain Power, you have an option that I'll talk about in a second to not have that rule apply. You've never availed yourself of that option, so I'm sorry, you're out. So, not surprisingly, following that case, Rocky Mountain Power said, remember that option you said we had, Commission? I'd like to exercise that. And that option is this. Under the Commission's rules back then, and again for a long time previously, going back to the 1970s and the volatile natural gas days, the Commission has a process, like most, maybe I should say every other state, that allows utilities, both electric and gas, to flow through price increases for their fuel cost. These fuel trackers, as they are sometimes called, very commonly in place. And the Commission had at the time, and still has, a rule for what is called a pass-through mechanism or a pass-on mechanism. And if a utility applies for this mechanism for a specified category of expenses, in particular, wholesale fuel expenses, the utility is allowed 100% pass-through of those kinds of expenses. So fast forward a few years to 2004, after the dust had settled, and Rocky Mountain Power came to the commission and said, we want a mechanism to flow through our, what they called net power costs. Now, the problem is when PacifiCorp proposed that, they proposed in some ways helpful, but in other ways not helpful, but a complex mechanism. They proposed a mechanism that had this what are called deadbands, which means that as power or fuel prices rise or fall, within a certain level, there is no charge to customers or credit to customers. But then once you get beyond that, then there's sharing. And importantly, they propose to include the amount of the kinds of costs that go beyond what the commission's rules allow in pass-on mechanisms. Rocky Mountain Power said, look, we have all of these things which they call net power costs. And it's a whole bunch of different things, some of which are tied to wholesale fuel prices, but more stuff as well. And they said, we want this mechanism to track all of that. And the commission said, okay, I appreciate your effort, but you can't have that. One, pass-through mechanisms don't have sharing, but they're limited in scope. You can only do that for specified wholesale fuel costs. And you want to do more than that, and so you can't have it. So at that point, something very important happened. In 2004, or 2006, 2 years later, they came back to the commission and said, all right, we don't want to pass on. We don't want a mechanism under what at the time was section 246 and 250 of the commission's rules. What we want is an incentive, innovative regulatory system. Now, if you look at the section that this is under, it's 37-121. This is a rarely used, up until this point, part of the Wyoming statutes that gives the utility the right to ask the commission to adopt a non-traditional form of regulation that includes incentives or other innovative techniques relative to a particular kind of cost or a particular issue. Now, as far as I know, up until 2006, I don't think any utility had ever done anything under this piece of Wyoming statute. But that was the piece of statute that the utility applied under because the commission had said, if you want to do it, you got to do it there. And so that's what gave rise to this mechanism. Now, it was originally called a Power Cost Adjustment Mechanism, or PCAM. 2011, the name changed to be Energy Cost Adjustment Mechanism, or ECAM. But what has remained true, and what is true to this day, is that this mechanism is not a pass-through mechanism, which is allowed by the commission's rules at a 100% level. It is a utility voluntarily accepted incentive form of regulation. And because it is an incentive form of regulation, it is permitted to be broader than the simple pass-through mechanism under the commission's rules and encompass a wider variety of costs. Now, fast forward to today and why this has been an issue. Because when the commission did this originally and created the PCAM, originally, Rocky Mountain Power folks said, we want to do this with a sharing mechanism. So it wasn't like this was imposed upon them as a sharing. They started with a sharing mechanism. Now, over the years, that sharing mechanism was tweaked a little bit. They started with a deadband, like their original proposal, and then eventually we dropped that and we went to this mechanism that was 70-30. That was a commission decision. And then in the rate case in 2020, the commission scaled that back a little bit and said, we'll do 80-20 sharing. And now, as was been discussed, it's back in debate in the commission here today. But I go through all of this because this is the critical issue relative to the takings question. The reason this is not a takings and never has been is because there is absolutely a mechanism for the utility to cover their rates in traditional regulation. And that traditional regulation includes specific commission rules, now recodified at section 26 of the commission rules. A little while back, the commission, under the direction of the governor, went through a process to redo all their rules and simplify them. And so they moved it, but it's still there, section 26. And the rule allows PacifiCorp or anybody else who wants one to have a narrowly defined 100% pass-through for fuel mechanisms. But Pacificor in particular has never chosen that option. They have always chosen this incentive form of regulation because they want the cost to be broader, but they want to have their cake and eat it too. Because what they want is they want a broad-based collection of costs at the 100% level that the pass-through mechanism would otherwise allow. And that's the piece where we say, wait a second, how does that become anything related to an incentive or innovative form of regulation, which is the whole point of the statute that this mechanism operates under? So from WIAC's perspective, we have always argued that the commission, while we have ultimately come to accept the idea that we have this mechanism, we believe that having this sharing mechanism is a critical component. And why is it critical? We think that in between rate cases, it is important that customers and the utility share in the risk of changes in power costs. And if you change it to a 100%, as the company is requesting across the street, all of the risk of changes in volatility in the power cost markets, risks which I will point out from our perspective are heightened when you're talking about using an increasing share of interruptible type resources, all of those things are now being borne on customers, and none of that risk is shared by the utility. And we think that's wrong. We think that if we're going to have these incentive, innovative mechanisms in place, that we should continue to operate them the way that we have. Now, why are we putting this in statute? Well, two things. One is we were asked what our ideas were, so here we are, here's our idea. The other thing, which is honestly true, is that it does become sort of tiring. We now have had 4 consecutive rate cases where every case, the company is saying, let's get rid of this thing, and we say, no, let's keep the thing, and the commission has to sort of decide that repeatedly. And so it's just a pain in the butt, is sort of frankly what it boils down to. And so we would really like to have Wyoming policy say, if you want to use this statute, if you want to be operating under incentive, innovative regulation, it's got to have some bounds around it, which include sharing of risks. And it's not the kind of thing where utility, you get to have incentive, innovative regulation and pass all the risks of that on to the customers. So that's our perspective. That's why it's not a taking, because this is in order to get one of these things, the commission can't require the utility to have an innovative or incentive. They can't order this. The company has to ask for it. And so it's a very different world than respectfully Senator Scott was discussing because of the nature of this. Now, having said all of that, I also want to say, though, one thing which is important, I think that it's really important to link this concept, as I've been discussing, to this specific section of Wyoming law. And so I would, if the committee's pleasure is to advance this legislation, I would offer one suggestion to the committee, which is at the beginning of the added language, on line 7, where it says, if the commission approves any form of cost tracking mechanism, and then insert pursuant to this section, then this is the rule that applies. Because cost tracking mechanisms that aren't under this section, for example, cost tracking mechanisms under the pass-through approach, those are already in rules and are 100% on the more limited basis. And so from that perspective, I want to make sure that no one confuses this language as applying beyond the 4 corners of 121. And so our suggestion is to make that clear by incorporating that into the statute. Now, lastly.
I'm sorry, repeat that location?
Sure. Line 7, after the word mechanism, we recommend adding the phrase pursuant to this section.
Okay. All right.
Now, one other point, which is absolutely true, Black Hills has a different innovative mechanism that they have in place that was approved through a series of stipulations that has been approved by the commission. The Black Hills percentages are different than this. That's all true, and it is sort of then becomes a policy question how you want to approach that. One way is you could just say, Black Hills, suck it up, you're doing it this way. That's an approach. Another way is to make this only applicable to big utilities and use the customer count numbers we've talked about before. A third way to do it, which is not my preference, but which I will acknowledge would at least be an improvement, is to remove the percentages and just say that if you do this innovative regulation, you have to share something, that it can't be 100%. And if you wanted to take that road, if you were concerned about the applicability of this to MDU, you could modify the language by simply, after on line 9, where you say, shall provide for a sharing of those costs, say, instead of where, say, between customers and the public utility. And then delete the rest. That would be a way to approach that. Like I said, I strongly believe in the 70-30, but I understand that that's a complicated decision that the commission is weighing right now as we sit here. But I think from a practical perspective, it would at least be nice that Pacificor stop asking for 100%. Last point I will make, this wasn't the origin of this, but if you have any concerns about the viability of this sort of legally, Montana has a statute mandating that all cost trackers in the state of Montana have a 90-10 sharing mechanism. That statute in Montana has been in place for many years, and it's never been challenged by any of the utilities in that state as unlawful or constituting a taking. And I believe that Northwestern is as litigious as anybody, and so if they had a concern, they would have raised it. But you would not be the first state to embark upon this path. Montana already does this.
Okay, questions for Mr. Nelson? Representative Yen.
Mr. Chairman, thank you. Mr. Nelson, I think this is an appropriate place to have this in legislation and not in the commission's hands this time. So my question to you is actually, are there any, I mean, it sounded like from Mr. Burbridge that there are cost tracking mechanisms that are greater than 70% currently enacted. Is that true?
Mr. Nelson.
Mr. Chairman, Representative Yen, yes, not under this section of law. Under the rest of this Title 37, there are mechanisms in traditional regulation, these fuel trackers that operate at 100%, but those trackers are very limited by the commission's rules to only be applicable to wholesale fuel costs. And so that's the reason why I believe Pacificor never went down that road in the beginning, because it's a more limited mechanism. But they're very commonly used, in particular by natural gas utilities here in Wyoming, who have these mechanisms to pass on the cost of gas that they acquire in the market, and the rates that the commission regulates is mostly the pipes, frankly.
Mr. Chairman, follow up.
Yes, sir.
So just to confirm, under this current section without amendment, there are currently no approved cost tracking mechanisms by the commission that are greater than 70% cost share.
You mean the Black Hills 95.5, but Mr. Nelson.
Mr. Chairman, Representative Lynn, yeah, so there are mechanisms that are above 70-30 and that mechanism in particular is Black Hills. And Black Hills can explain this. They have a more complicated system. They have a higher sharing percentage that goes up to 95.5 for what they define as uncontrollable costs. And then they have a bigger sharing band for costs which the commission has decided are in the company's control. So their structure is a little more complicated, but it goes up to a 95.5, and that is within this section of the law. It was an innovative form of regulation that Black Hills adopted.
Mr. Chairman.
Go ahead.
Then if I may, Mr. Nelson, if we did enact this, would that affect the currently approved mechanism that Black Hills already has?
Mr. Nelson.
So if it was enacted as written,
yes,
it would force Pacificor to go from their current 80-20 to 70-30, and it would force Black Hills to go from their current mechanism of 95.5, and I forget what the other percentage is. I think it's 85-15, but I'm not positive. But whatever their mechanism, it would force Black Hills to also go to 70-30. So if you adopt this, it would move both of those in sort of what I think is the right way, but a controversial way. If you adopt the alternative version of the legislation and simply say, provide for a sharing of those costs between the utility and customers, that would not change any of the currently effective mechanisms, because both the Black Hills mechanism and the RMP mechanism have a sharing in different levels. But and I say that I'm not 100% sure. I don't know if MDU has one under this section. So I'm gonna have to, someone's gonna have to tell me what the answer is for MDU. But I know if you did that, you certainly would not be impacting the current structure of Rocky Mountain Power and Black Hills. What you would be doing is impacting what Rocky Mountain Power is currently asking the commission to do, which is to go to 100%.
Anybody else for Mr. Nelson? Senator Scott?
Mr. Chairman, following up on that, what I'm going to suggest is that and I'd like your reaction to it, we put in your amendment on the pursuant to this section. I think that's really important. And then I'm going to suggest that we provide for if the smaller ones having to have a sharing between the customer and the utility. And then if they have more than, say, 100,000 customers, we provide that the sharing will be the 70-30. In your judgment, would that solve the problems? We might have to refine the language at the session, but it would put it in the bill so we wouldn't be changing the bill too much.
Are you asking me, Senator Scott?
No, Mr. Chairman, I'm asking Mr. Nelson.
Because my judgment would be that that would make Mr. Nelson very happy, but I will yield to Mr. Nelson.
Mr. Chairman, Senator Scott, that would make me very happy.
Mr. Chairman, I thought that was the case. Mr. Chairman,
We won't address an amendment at this time. Keep it parked up there. Any other questions for Mr. Nelson? Mr. Nelson, I do have one. I mean, literally, what is the practical effect if this is in the 2024 legislative budget session? It has an effective date of July 1, 2024. Commission has a proceeding that's going to have an order on this issue before, of course, the commission could take note of pending legislation, but it's not law. And in practice, the commission could order something and then the company might have to come in again after July 1. Is that the way you see it?
So,
Go
Mr.
ahead.
Chairman, the good news about this, I mean, the good news such as it is, the rate case is currently debating the structure. But the reality is that this operation of this sharing mechanism, it happens every year in the utilities annual, in the Rocky Mountain Power cases, ECAM filing.
Mm-hmm.
And so I think that to the extent, if the commission, for example, either kept the 80-20 or went to the 100%, the reality is that by the time the next ECAM cycle, if you would, came into being, if this legislation were enacted, it could then be implemented in the ECAM. And so I think that because the ECAM happens every year, no need to wait.
I got you. Thank you. Appreciate that. Representative Yen.
Thank you, Mr. Chairman. Mr. Nelson, so if we leave the 70-30 in at some extent, I think what I need to understand is what is the justification of that ratio versus some other ratio? Do you have a justification?
Mr. Chairman, Representative Yen, so the 70-30 was adopted by the commission when they implemented the first of these mechanisms back in 2006. And the commission at that time weighed a variety of different options and considered the testimony of a variety of different experts in terms of what the appropriate level of sharing is. And what the commission ultimately, I think, landed on was a couple of things. And you could get this out of the decision and the cases involved, which I was part of, so been around doing this for a while now. The commission was focused on trying to make a determination of what the percentage of the company's costs in between rate cases they feel like they have some legitimate control over, and what the percentage is, which is simply the company taking the prices from the wholesale gas or the wholesale coal markets that they can't really control. And so when you look at what these percentages are, it's a judgment call tied to a question of what's really within the utility's control and what isn't. It is also a consideration, the commission talked about this, of trying to decide, in a context of innovative or incentive regulation, how do you provide a meaningful incentive that at the same time doesn't overly punish the utility for things that aren't something that they can manage? And so when they looked at that, they weighed a number of different options and came to the conclusion that 70-30 was the right balance. Now, in 2020, the commission reevaluated this and they said, look, in light of some changes, we feel like maybe going to 80-20 is a better option, although I will point out one of the current commissioners dissented on that particular issue. And so, it's still, I think, an open judgment about where that goes, but it really boils down to that question. And that's where the commission found the evidence historically and then updated that thinking a few years ago.
And now they're doing the exact same thing.
That's right. And now they're doing it again. And from our perspective, we think the 70-30 was a better number and that it was right when the decision was made back in 2006 and was in effect between then and 2020. But having said that, that's where the debate is. And certainly, as has been mentioned earlier, reasonable minds can differ on what exactly is the right number. But that's the number the commission landed on, and we think with good support.
Okay. I think you're off the hook, Mr. Nelson.
Great. Thank you very much.
Mr. Garlish, come on up. You look pretty enthusiastic.
Yeah, not really. Richard Garlish, Rocky Mountain Power. I'm going to start at a higher level. I think what we heard of is a long history about a complicated issue that was litigated, and then was litigated again, it was litigated again, and it was settled, it was litigated again, it's being litigated right now. And people will have different positions, I guess, about the outcome of that. I'm not sure that frustration over the outcome of the litigation and the subsequent appeal and relitigation is enough to warrant a statutory cap. In our view, the commission is the judge and jury, and they have the obligation and the responsibility and the authority to, as Mr. Nilsson said, take evidence from the experts, weigh the balance of interests, and come up with the sharing band. And as a participant in the process with the obligation to seek the recovery of our cost and put on a case, we have the right to put a case for 100% and not a sharing band. And if we lose that, we lose it. If we win it, we win it. And so I'm not sure why it's okay for, Black Hills to litigate it. Commission take evidence on that, come up with a band, and that's okay, but not us. So, I think it's obvious we oppose this bill. We do think, and it's being litigated across the street with experts with hundreds of pages of testimony on both sides about the pros and cons of whether it should be 100 or be 70 or better than 30. But I do not think that this forum or this tribunal is the right place to litigate this issue or sit as a court of appeal of the commission's decision. I just don't think it's appropriate. So I'm not going to go into litigate it or go back to 20 years forward and how we got here, other to say it's being litigated where it should be litigated by people who should be litigating it, and we're prepared to make the case and stand by the decision. Unless there's any questions, I'm done.
Thank you, Mr. Garlish. Appreciate that. I know this seems kind of frustrating, but the whole world's frustrating for us in the electric world now.
Yeah, we all get to take a chance of being frustrated. So I appreciate the grace for my 5 minutes of it.
You certainly have it. Senator Boner.
Thank you, Mr. Chairman. So I think that this is, it sounds like we can't talk about this rate case because it.
Oh, yeah, we can.
And so it seems like this is a pretty major part of what you're asking for. And so I'm wondering if you just might give us, in rough terms, you're asking for 100% of these costs to be passed on to the ratepayer. So how much does that account for the increase you're asking for in rough percentage terms?
Do you know?
I don't know the rough percentage of the increase. I don't know that answer to that question, but I do generally our position is that, and there's differences. Mr. Nilsson has entitled his opinion and his advocacy about what is innovative and what isn't innovative and what are recoverable costs and what aren't. But that is precisely the thing that needs to be litigated across the street because of the complexity of it. Our position is that those costs are the costs. We had to go out and buy those purchases. We had to make those investments. And, you know, back to the regulatory compact of I'm supposed to be able to make my investments and get the return of the money I put out, plus a reasonable return. And, you know, this is in that ECAM bucket. But these market purchases, we feel that we're putting out the money for them on behalf of customers in a prudent manner, and we should be able to recover them.
Mr. Garlish, should I be wrong with this back of the envelope? I believe it was stated in some places that it was 105 million for net power costs. Is that right? Is that close? I'm just looking, if it's 105 million and then you apply these ratios, that might be, that doesn't work? I better shut up.
Yeah, I don't want to get over my.
Wax counsel is advising.
Well, you know, frankly, Chairman Case, and I don't think it's appropriate for me or Mr. Nilsson to be litigating our respective points here.
Well,
why the case is ongoing. So I'm not comfortable of trying to figure out how that would work, and I'm not the right person.
Yeah, it's okay. But just 1 second, Senator. I mean, on the issue, we can have a discussion. The case is being litigated over there. We're looking at proposed legislation. I think they're two different things, and we can hit hard in both forums. It's okay.
And I'm happy to, you know, please excuse my frustration. I'm happy to have the conversation. I've been trying to convey that over there. I just think for this one, it touches a core value. I think maybe for me and the company is that we have an institution. We've empowered it. The state has empowered it to sit as the judge and the jury on this. And we think that's where it belongs.
Thank you, sir. Senator Boner.
Good, actually.
Okay. Anybody else? Anybody else want to poke the bear? Go ahead, Senator or Representative Ottman.
Thank you, Mr. Chairman. Just a question for you. Going out there and when you do the purchasing, are you under any obligation to look at the market and try to purchase when the prices are good or as far as being low? Or is, because I had heard that one of the things is there was a purchase or maybe a group of purchases made to increase the amount of utility that was available to you, and at the price was no object. So I'm just.
Yeah, hold on 1 second, just take, the trouble with electricity is you got to deliver power to somebody. And so you don't really, you got to take what the market is telling you at that time, unless you have provided mechanisms to insure those costs. Maybe have it, you know, and there are contractual ways to do that. And it's whether you buy long-term versus the spot or produce the power yourself. It's kind of complicated. But if you're in a situation where you've lost other resources or they're not available and you're stuck with the spot market, you're stuck with that price. That's the way it works. Go ahead. For follow-up, we're going to let Mr. Garlish address.
Yes, and again, this is a real learning curve for me, so be graceful.
You're doing great.
There. Okay, how about storage? Is there storage?
Mr. Garlish, you can go back to the first part if you want.
Sure. Representative Senator Case. I think I want to address one thing right up front. We are nothing but incentivized to make prudent decisions about resource acquisition, resource dispatch, resource contracting, because every single decision that we make is scrutinized for prudency. So, you know, when we're talking about this 70-30 brand, it's really a subset of a subset of a subset of, you know, incentives and controls on the utility, the regulated utility, about how it makes its decisions. So, you know, we have the obligation to serve safe and reliably at the best possible cost. So when we go out into the market, you know, we are looking for the best deal. And sometimes the best deal is running our own, dispatching our own resources first, because the cost to produce our resources and deliver them is less than what's available on the market. But occasionally, due to system constraints or operational kind of considerations, it makes more sense for customers to go out and make purchases and not run the plant because the power might be more cheaperly available on the market than it is from our own production. So when we go out and make these purchases and the costs we spend to go out and make the purchases, we do that knowing that it's going to be reviewed and reviewed and reviewed again. And we have to demonstrate that we were prudent. So what does that mean? Based on what we knew or should have known at the time we made the decision. And that is the standard that the commission applies to us. So, we're just not going to be in a position where we just, we're not spending money to spend money. We're looking for the best deal for customers that we can get.
And then the question on storage.
Yeah, Senator Case, Representative Ottman, I'm not really sure what the question about storage was.
I think, can't you use storage instead? Would that be fair?
Yeah, so when we look at dispatch in the portfolio, so we have a portfolio of energy resources in different timelines, and we project in the future what the load is going to be. We talked a little bit about the IRP, and that's the farthest out as possible, and that's really the planning for resources. But you have real time, day ahead, balance a month, and term in the year, and we're always looking out in the future about what is the demand going to be, what's the load going to be, and then what do we have in our resource stack to meet that demand in those timeframes. So we have our base load resources, we have our renewable resources, we have market purchases, and we have the EIM market, we have demand side management, and it's running scenarios to determine what is the most economic purchase we can make for customers, or operational decision we can make for customers to serve the load.
But,
and storage is part of that.
Yeah.
Yeah.
But storage isn't a very big part of it. The best batteries out there, and I've heard different things. I mean, you can have big banks of batteries, and they have them in neighborhoods in California now, but they're only like 4 to 8 hours of availability. They're not beyond that. There are other techniques for storage, one is called pumped hydro. It shows a lot of promise. It's really expensive, but you might have more of a possibility with those. If you have a lot of hydropower that's available and there's water behind it, that's a form of storage right there. But we've had some dry years. As an investor-owned utility, they're a little farther down in the allocation of hydropower resources than, say, our good friend from Teton County, who has, being on the Columbia River drainage, he has access, his cooperative has access to some of the cheapest hydropower available. And that's kind of a form of storage too. You get to choose to use it now or you lose it later, but storage isn't really very practical in this world that we're talking about here. What's really happened is you need power tomorrow afternoon. It looks like the wind's going to die off. You've got this coal plant is down for maintenance, or you can't get it up to that level that fast. For some reason, this power is committed over there. It looks like we're going to have to make up the gap, and we're going to have to purchase on the market, and here's what it's going to cost. This is what they're quoting us. It's really, it's hour by hour. They do like a 2-day forecast and then a 1-day forecast, and they're managing this all the time. And they're raising up the coal plants. Literally, they can tweak them every 10 minutes, but you can't cold start them. It takes days and days and days to start a coal plant. It's really complicated business.
I'd agree.
Okay, any other questions for Mr. Garlish? Thanks. Mr. Bush, 95.5. 44,000 customers. And one mad lobbyist who lost his Christmas party prize.
I am already hearing about that, Mr. Chairman. The committee is invited to the Christmas party, by the way. They did want me to extend that to you. Thank you for that. So again, David Bush with Black Hills Energy. Opposed to this legislation, I think probably for many of the reasons that you've already heard from Mr. Garlish, and I think even Mr. Burbridge with the commission talked about how tricky this can be to put these bans into statute. I have to admit that this is not an area of expertise for me. I am a humble government affairs guy and not a regulatory person, but the folks that I lean on to help me with this stuff have brought up some questions, and I think they would be they'd be helpful here as well. So going back to our conversation earlier about Storm Uri and Texas, that weekend, I believe it was a weekend, we spent more money on natural gas procurement than we spend in a year, generally. The price spiked because of availability, and we had to pay for that. Now we've gone and set up a schedule with the commission, recovering those costs over 3 years to kind of lessen the load. But I think it proves the point of the volatility of these energy sources. Now, one of the questions that was brought up by a member of my team was, if this were to pass, there's a chance that we would be coming back for more frequent base rate cases because we would be asking to recover those costs, which in a rate case, my understanding is all costs are brought in, not just the fuel costs. So we could be in a situation where we would have more frequent rate increases to help offset some of these costs that we're seeing. It's not something we enjoy doing, I can tell you that. And again, my legal and regulatory folks are not super excited about doing more rate cases because it's not fun, and I'm not, our customer service folks aren't. We don't like to do that kind of thing. So I think those are some of the questions that have been brought up. We, as some of you know, we have our own coal mine, so we dig our coal, put it on a conveyor belt, run it under I-90 outside of Gillette, and burn it in our plants across the interstate. So we're in a pretty unique situation where we're not as tied to the fluctuations on the coal side, but it does still change, right? And there's a lot of factors that go into that. So as the costs change, I think that's where we always get a little concerned about putting stuff into statute. I think it's probably not the same, and it's a word that, or maybe two words that nobody likes to hear, but this reminds me of the only place in statute that we have rates that are set on the electric side is net metering. Very much the same situation to a degree. So I guess I would caution the committee in thinking about this, that, and it is very, I mean, I realize that I'm sounding very self-serving sitting up here saying these things, but I think it also points to that we have customers that are relying on us to make the best decisions we can for the cost of power and procurement, and making sure that we're doing everything we can on keeping costs down. And so I think I'll stop there. Probably rambled enough as it is.
Everybody's tired, but I think you did a good job. Questions for Mr. Bush? Questions? Thank you, Mr. Bush. Who else would like to address the committee? Not seeing anybody else. Anybody online? Committee, have you heard the testimony? What's your pleasure? Senator Scott's moving towards the computer. Are you going to give us a motion, Senator Scott?
Mr. Chairman, if you want, I'll move the bill.
Okay.
Do you want him to?
I'm staying. I'm want to let the committee lead. Got a motion by Boner. Is there a second? Second by Ottman. Discussion.
Mr. Chairman.
Senator Scott.
Mr. Chairman, it seems to me that there's probably 3 amendments that are needed to the bill. One of them is the pursuant to language, so that we're confining the rate setting to this innovative thing. I thought Mr. Nelson made a very appropriate case for that. Second, Mr. Chairman, I think that the, there's quite a difference based in part maybe on the size of the utility and the number of other states they've got to deal with, the nature of those states. We probably need to make a distinction there. And I will propose an amendment on that. And then, Mr. Chairman, I think we can put the 70-30 in statute, but I think long-term, we need to give the Public Service Commission authority with some sideboards and some standards on which to operate, to alter that as time and conditions change. And frankly, I think that's something we're going to have to do during session. So, Mr. Chairman, if it's all right with you, I would like to proceed down the first two amendments. And first, move that after on page 3, line 7, after the word mechanism, we insert the words pursuant to this section as per Mr. Nelson's recommendation.
Do we have a second? Do we have a second? Second by Boner. Discussion? Any discussion? Ready to get that?
Mr. Chairman, is that
Representative
for
Yen?
all 3 amendments that he wanted to do?
No,
or-
it's just for the
Sorry.
first.
Thank you, appreciate that.
Let's, it's getting kind of late. We'll take a break right after this bill, promise. It was with the pursuant to this section amendment. Okay, that's all it is. All those in favor signify by saying aye. Opposed? That's passed. Back to you, Senator Scott. We're going to offer the second one.
Yeah, Mr. Chairman, on page 3, line 10, after the word customers, insert the language and the utility for a portion of the cost and if the utility has more than 100,000 customers in Wyoming, and then you return to the existing language. The utility utilities are responsible for not more than 70%.
Okay. So Senator Scott, it's kind of late. That's kind of the one option. That is appropriately dials in the 70-30. And if with your permission, we could pursue that and see if you got a second. I'd kind of like to do a straw poll if anybody else is interested in the other option that just says there'll be a sharing mechanism. Is that of interest to anybody?
Mr. Chairman, I would propose that if this amendment fails.
So kind of have two competing concepts, Senator Scott. I'm just trying to pick the one that the committee might want to go down easiest to try to save time. So if I could do a straw poll, how many, and the two questions are going to be, who prefers the 70-30 ingrained in the bill? And then the second question is, who prefers that there just be a sharing mechanism? Those are the two questions right now. And so who prefers the 70-30, just conceptually? I got 1, 2, 3, Senator Scott, 4. Who prefers the more loose language that there just be a sharing mechanism? 1, 2, 3, 4. I'm going to go with that group. So Senator Scott, I'm not really sure. There are a couple of people that didn't vote, so maybe we can get it through, but that's the direction we kind of have looking at the traffic lights ahead.
Mr. Chairman,
Yes, sir.
Mr. Chairman, I think if we do it that way, you say starting on line 9, the mechanism shall provide for sharing of these costs where the customers.
You might
and-
just put a period. Mr. Nelson, can I purvey it on you for the language right there? And would you come to the microphone? Hold on, Senator Scott,
You can probably do it better than I can, Mr. Chair.
we're gonna get real language. Hold on. Mr. Nelson.
Mr. Chairman, members of the committee, based on the discussion that you were having, the suggestion that I had made to implement that approach would be on line 9, strike the word where and everything that follows, and replace it with between the public utility and its customers.
Okay. Senator Scott, did you hear that?
Yes, sir, Mr. Chairman, I move.
Okay, motion by Scott. Is there a second? Second by Yin. Discussion? Everybody got it? All those, Representative Ottman?
Thank you, Mr. Chairman, and not to get in the weeds, but to say, okay, if there's a sharing, what does that mean?
Right, it doesn't specify the 70-30 or whatever. Just says if you're going to use this mechanism for innovative rates, you got to share. And it
So-
has the practical effect that it does prevent what Rocky Mountain Power is proposing now, because they're proposing to use this mechanism with no sharing. But it doesn't specify 70-30 or any other number.
Okay.
And it wouldn't impact the current, it wouldn't impact, it could impact the current case because Rocky Mountain Power may not get its non-sharing proposal. It would not impact other companies that are using this and are sharing now. So
Thank you.
it's sort of in its spirit defers more to the commission. Okay, call for the question. All those in favor signify by saying aye. Any opposed? Got to know. And so now I'm not going to call them. I didn't mean to call you in out. You know, I like them both. So I might call you out. We're back on the bill. Is there anything else on the bill? Representative Harrelson is waving his name tag at me, so we are back on the bill. Is there anything else on the bill? Senator Barlow.
Thank you, Mr. Chairman. So I always find it interesting that we like effective dates that are July 1, and I think that's standard for a lot of things. But some of these bills, and we've gone through several of them now, it seems like effective immediately. I won't make that motion today, but I think as we get closer to the session, looking at how people are actually putting in things, we might have people trying to beat the deadline on this.
Well, we can always
If the bill
change the
gets-
effective date
okay.
because
Anyway, thank you.
the front of the bill just says providing for an effective date. So it could be changed later. Okay, I'm going to call for the question. Can we have a roll call on the bill?
Mr. Chairman, roll call for 24 LSO 0274, Public Utilities Net Power Cost Sharing Rates as a ratio, as amended. Senator Barlow.
Aye.
Senator Boner.
Aye.
Senator Landon, excused. Senator Scott.
Aye.
Representative Chadwick.
Aye.
Representative Harrelson.
Aye.
Representative Harshman, excused. Representative Knapp.
Aye.
Representative Newsom. Representative Ottman.
Aye.
Representative Wiley.
Aye.
Representative Yin.
Aye.
Chairman Case.
Aye.
Chairman Olson, excused. 11 aye, 3 excused.
All right, let's take a break. We certainly deserve it. Do you think we can keep it to 10 minutes and come back at 4? The only reason is Friday. The roads are not that great and people want to go home. So 10 minutes, 4 o'clock.
Oh.
everybody, if we could come back together and just try to do our best. The next bill for our consideration is 24 LSO 275, Public Utilities Energy Resource Procurement. Mr. Anderson?
So, Mr. Chairman, this one was also requested at the end of that last meeting here in September. This bill is also based on what Utah does. It provide for a solicitation approval process for acquiring or constructing significant energy resources. It's just going quickly through the bill, Mr. Chairman. Subsection A, starting on top of page 2, is the applicability section. This applies to affected electrical utilities. Again, that's defined similarly to the other bill. So we need to determine if we want to have that same definition that we adopted as amendments to that first bill this afternoon. So the affected electrical utility is required to comply to acquire or construct a significant energy resource. That is also defined, that's later in the bill, after July 1 of 2024. Subsection B provides for that solicitation approval process. Solicitation is also defined at the end of the bill, and it requires the electrical utility to conduct a solicitation process approved by the commission and file a request for approval that includes a description of that process. In ruling on that request, the commission at the bottom of page 2 may hold a public hearing and shall provide an opportunity for public comment, shall determine whether that solicitation process complies with this section and rules and is in the public interest, taking into consideration a number of factors that are listed there, including acquisition, production, and delivery of electricity at the lowest reasonable cost, looking at the long-term and short-term impacts, risk, reliability, financial impacts at top of page 4, and on the utility and other factors determined by the commission. The commission may provide guidance on or additions or changes to the solicitation process. And then within 60 days, the commission is required to either approve, suggest modifications to, or reject the solicitation process. Subsection C, starting on page 5, is a waiver process where a affected utility could not comply with the requirements of subsection B in the public interest, in the case of an emergency, a time-limited opportunity, or other factor determined by the commission. It requires the commission to adopt rules regarding that waiver process, including providing for a technical conference, and you can see some details there, a time frame in which that is required to be held of not less than 3 business days and not more than 7 calendar days, provide public notice, and require the public utility to provide support for the waiver and respond to questions at that conference. Over to page 6, the waiver process would be required to provide a mechanism for people to file comments, and then a written decision within 7 calendar days. Would require inclusion of a statement that any waiver is subject to further review and does not create a presumption that acquiring the resource was prudent. The rules shall specify that the commission may decline to use an independent evaluator, which is discussed later in the bill, for this process if the use of that evaluator is not appropriate or available within the time period. Subsection D, starting on page 7, these are requires the commission to adopt rules related to this solicitation process, provides that the rules may account for consideration of the impact of multi-state regulation on the solicitation process. And then towards the bottom of the page, the rules shall include the type of screening criteria the utility may use in the solicitation process, required disclosures by the utility and participation of an independent evaluator. Subsection E there on page 8. These are the requirements related to independent evaluators. They're required to monitor the solicitation and approval process and report to the commission and others as directed by the commission. Commission's required to adopt rules on page 9 related to independent evaluators, including qualifications and the method to pay for them. Subsection F at the bottom of page 9 are the definitions. Again, there's the same definition for affected electrical utility. Over to page 10, definition of significant energy resource. You can see in general, these are resources that are 100 megawatts or more, and a dependable life of 10 or more years. There is one exception to that. Subsection C would have that be a purchase or lease from an affiliated company, would also be subject to this provision. And then subsection E would provide the commission the ability to add other types of resources. And then finally, the definition of solicitation on bottom of page 11, a request for proposals or invitation to submit a bid or proposal through an open bid process for construction or acquisition of a significant energy resource.
Thank you,
Bill,
Mr.
Mr. Chairman.
Thank you very much. Questions for Mr. Anderson? Any questions for Mr. Anderson? Thanks, Josh. Mr. Burbidge, you want to go first?
Thank you, Mr. Chairman. I will confess that I haven't had an opportunity to go through this bill with a fine-tooth comb to any extent, but would note that it does share some issues as the IRP legislation that would propose legislation we were talking about. Well, nonetheless, I think the issue of should the cooperatives be bound to this sort of a bill is an issue as well, and I don't know that it would be appropriate for the cooperatives to be affected by this. A bigger concern is the timeframes set forth in subsection C as far as the waiver goes. It seems that whole section could perhaps just be handled, that waivers that the commission could draft rules and regulations to address a request for a waiver. We already do that to a certain extent with making a determination as to whether a certificate of public convenience and necessity application needs to be filed. We have a provision that allows the commission and its staff to look at a proposed project to determine if it's a project that for a particular utility is in the ordinary course of business. So we have a little experience with how long it takes to process something like that. I view this as being similar to that situation, and that we could incorporate that into our rules as we've already begun to do that. And then, it does present the same issue with do you look at this as far as limiting the utilities that would be subject to this by the number of customers, which of course is different than Utah. So that issue is before us again. And so with that, I don't have too much more to say about the bill. And I would stand for questions that I may or may not be able to answer at this time of day.
Thank you, Mr. Burbidge. Questions for Mr. Burbidge? Senator Scott, your hand's up.
Yes, Mr. Chairman, or Mr. Burbidge, assuming that, and I apologize if I butcher your process at this hour of the day, assuming that we restrict this to the larger utilities, is it your judgment that are they already doing this sort of thing? And if they're not, is it your judgment that we're going to save the ratepayers money by passing this bill and requiring the solicitation process?
Mr. Burbidge.
Mr. Chairman, Senator Scott, I haven't thought through this bill as with regard to if it's going to save ratepayers money, although I think it does give the commission the opportunity to look at certain projects in advance of a application for a CPCN. We, I think, are seeing more instances of CPCN applications being filed after an RFP process has already concluded. The problem with that is that many of the issues that we normally look at in a CPCN case have already been addressed by a utility and pretty much taken care of in that RFP process. So in some respects, this bill is to allow the commission the ability to examine a potential, for instance, a wind project facility that perhaps that has already been pretty much sorted out on the is it a prudent investment? Those issues seem to go away, if I remember correctly, after the RFP process is already done, and then it just becomes an exercise of the necessity of the project. And so it seems that it would give the commission more ability to take a deeper dive into the prudence of the project overall if the commission's able to engage in some of the RFP processes at the front end.
Thank you. Anybody else? Senator Barlow.
Thank you, Mr. Chairman. So as I'm reading the language, acquire or construct significant energy resource identified below. Now, to the point that you were just talking about the sequential component of this, my understanding was, Mr. Burbidge, was you were saying this actually came in front of the RFP, which would then be if this were completed, then the RFP process could be completed, and then you may get to a CPCN. I just want to understand sequentially where this is. It seems like this is well before a CR certificate, but where is that? Thank you, Mr. Chairman.
Mr. Burbidge.
Chairman Case, Senator Barlow, yes, that's precisely it. We've been seeing CPCN applications that are simply for the acquisition of projects, and so that limits, we believe, our ability to look at some of the other aspects of the project with regard to cost of construction and so on and so forth. So we're then merely looking at it, is it a necessary, does the utility, is the project necessary for the utility's operations? But it takes away the examination as that we normally have with the CPCN to make sure the permitting is lined out, right-of-way issues if they're there, things that we would normally be engaged in. Those now we're just down to looking at an acquisition issue in a CPCN, and the project is already, from what it may be. Speculation here. I mean, they may have turned dirt already on it if they've not, if they're just looking at purchasing it at the end of the day.
Anybody else? Just to be clear, that you mentioned wind, but this would not apply to independent power projects that were PURPA-based. I don't want to get people riled up. So they would still come under the PURPA requirements because of the unique situations in Wyoming, I think.
Mr. Chairman, that's an excellent point, and I perhaps used a bad example, but
yeah,
it doesn't. This wouldn't prevent any QF type projects.
Qualifying facility under the public utility regulatory. I can't remember. I'm drawing a blank. But anyway, it's the relatively. They're big, but they're relatively small in the utility world. Renewable projects that the utility is forced by federal requirements to purchase the power. So anything else from Mr. Burbidge? Thank you, Mr. Burbidge.
Thank you.
Who wants to go first? Mr. Nelson. If you can shorten anything, it'd be good. I know that's hard for you.
That is so hard. Thank you, Mr. Chairman. I will be pithy. So this bill that we had proposed, and we really appreciate the committee taking a look at it, is really kind of what I perceive as a companion to the IRP bill. Just at a high level, the way the process works for the acquisition of new electric generation resources is first you have the integrated resource plan, which looks to this long-term need. When the plan figures out that there is a need, in part based for Rocky Mountain Power on legislation that already exists in Utah and Oregon, then the idea is we need to figure out how we're going to meet that need. And so oftentimes they will do, if there's enough time, what's called issuing a request for proposals, or RFP. And what that does is it sends a message out to the general community of people who build electric generation facilities. Let us know if you have a project that you want to bid into the RFP. PacifiCorp will bid their own self-build projects into that RFP, and then weigh which of those projects makes the most sense. Once they pick a collection of a resource or a suite of resources, they then go to the third step, which is that CPCN that we've been talking about, and ask for specific commission approval to build the specific thing. But what's missing, and what's the part that this legislation is designed to address, is when you're in that RFP, that's really when you have optionality. That's really when you can say, okay, I really want that project and not that project. Because by the time you get to the CPCN and that RFP is gone, those bids are gone. The people who bid them are no longer obligated to hold to those bids. And so you can't go back and say, gosh, I really wish you'd picked that other one before you came to me in the CPCN, because that's no longer an option. And so the idea that for this, and the reason why this is the law in Oregon and Utah, is that the commission say, we want to make sure we're injecting ourselves into the process when you're picking amongst a group of options. And lastly, I will say this is particularly important, and this is from WIAC's perspective. We believe, and we have seen issues, and I've talked with some of my colleagues in Utah, that there are some question marks we have about the way PacifiCorp conducts RFPs, and in particular, whether PacifiCorp is giving, from our perspective, full value to fossil fuel-fired resources in those RFPs, or is, in the great complicated behind the curtain, got their finger on the scale to not pick those options. And so from our perspective, the real guts of this bill and what we're really hoping the committee will see the value in is the independent evaluator. Because what the independent evaluator does is it allows the commission to hire an expert using money paid by people who bid into these RFPs. And that expert then goes behind the curtain and looks at what the utility is doing and makes sure that they are correctly applying whatever guidance and directives they've been given by the commission about how any resource selection ought to be accomplished. And it is that access to being behind the curtain in the RFPs that then allows the states who do that to make sure that their policy considerations are being fairly and faithfully applied. Now, to Senator Scott's question, will that save money? I don't know. I mean, the truth is we have solicitations for PacifiCorp, and the folks in Utah and Oregon are looking at the money thing. But for me, the real question is, do we think that they're picking the right resources in those processes? And that's where Wyoming has a unique and perhaps different perspective than the other states, and why WIAC thinks it's good for us to have a seat at that table. Now, last thing I will say before I let it go is I think that this is another one, like the IRP bill, that it would be perfectly rational to exempt the cooperatives from. I don't know that there's a compelling reason for that. I will also note that relative to MDU, for example, there's 100 megawatt, it's not cap, it's whatever the bottom is of cap. There's a 100 megawatt minimum before this statute kicks in. And given the size of MDU's operation, that's naturally going to kick in, might apply to Black Hills. But for my money, again, the real focus for us is on PacifiCorp and Rocky Mountain Power, for the reasons I've stated. Happy to answer any questions.
Questions for Mr. Nelson? Questions for Mr. Nelson? When we get to exempting the cooperatives, the mechanism we used before could be put in here?
Yeah, I think the exact same amendment in the IRP bill would work in the section at page 9, line 21 of this legislation is identical. You could do the same thing.
Yep, we have to let Mr. Taylor propose that, because in that way it gets paid.
I have no issue with that. I don't want anyone to think Mr. Taylor's not doing his job.
Excellent. Thank you.
Thank you.
Mr. Garlish.
Richard Garlish, Rocky Mountain Power. I'll be extremely pithy. We're okay with this bill. We do it in Utah, we do it in Oregon, same kind of thing. As long as we can kind of line it up and manage the work, it's something we do. We're good with it.
Thanks. Any questions for Mr. Garlish? Thanks. Who else would like to address the committee? Who else would like to address the committee? We got anybody online? Ms. Anderson? Looking for you. Okay, we've heard the testimony. What is the pleasure of the committee? Motion by Barlow. Is there a second? Second by Knapp. Discussion. Mr. Taylor, you sure you don't want to come up and ask for that? I mean, your parents are here and we want you to get all the credit for the home run for the team. Okay, we get that point. Anybody else? Discussion, any amendments? Senator Barlow?
Thank you, Mr. Chairman. So page 5, there's a subsection C, and this goes in, then it goes into Romanettes 1, 2, 3, I, little I, et cetera. This is all the rules that are necessary. And I guess I am, having previously served on a board of the state of Wyoming and had both latitude and direction in statute about what goes into rules and what doesn't, sometimes becomes challenging. So I guess I'm just going to ask you for your sense, based on what Mr. Burbridge said about they already have some of this in place for these type of things. And I'm wondering if we just say the commission may adopt rules regarding the waiver process, period, and delete all the requirements. Mr. Chairman, do you have any thoughts on that type of an approach?
I think that could work. Mr. Nelson, what do you think? That basically takes the whole of section C on page 5, collapses down and says, we could make it, leave the first sentence, say, an affected electrical utility may obtain a waiver of the requirements of subsection B of this section if the commission determines that waiving the requirement is in the public interest. Kind of just do that and let the commission establish rules to implement it. There's a lot of framework in here. We'll let you weigh in on that.
Mr. Chairman, Senator Barlow, from WIAC's perspective, we would have no heartburn with deleting, starting on page 5, line 11, the phrase, the rules shall include, and deleting then the subsection I, 2I, 3I, 4I, and 5. We would not recommend changing the shall to a may on line 10, because we think rules will be very important. What we've seen in other jurisdictions is if a waiver is needed, it's usually because something has to be done in a pretty short time frame. Right. And so having some structure is helpful, but completely agreed that the commission can define a process that works for them.
Thank you, Mr. Chairman.
Thank you.
Thank you.
So,
Is there a motion?
So, Mr. Chairman, I would move to strike everything from line 11, page 5, after the period.
The first period. Yeah, there's only one period.
There's only one period. Through page 5, onto page 6, onto page 7, line 6.
Is there a second? Was that Mr. Burbridge seconding that? I thought it was. Who gave the second? Chadwick, thank you. Discussion? Ready for the question? Everybody get it? All those in favor signify by, I'm getting tongue-tied. All those in favor signify by saying aye.
Aye.
Opposed, no. That is passed. We think, Senator Barlow.
Thank you, Mr. Chairman. I would like to make page 9, line 21 through 23. I'd like to have the same definition that you ended up with on the
Cooperative utility?
IRP bill.
Yeah.
In IRP bill, replace this language. Thank you, Mr. Chairman. That's my motion.
And that's the same reference to the definition of cooperative utility. Mr. Taylor, are you good with that? Got it. Is there a second? Second by Haroldson. Okay. Discussion? All those in favor signify by saying aye. Aye. Opposed? No. That's carried. How about the size of the electric utility? Right now, we got to deal with that. It's got the same staff
Mr. Chairman, if it's the same definition, it would work out the same way.
Well,
Because
we kind of had two amendments on that
so I
previous
think if we
section.
match the definition, it takes care of both issues.
Right,
we match
Mr.
the
Anderson, but as I understood it, it was just respect to cooperatives. Was that wrong?
Mr. Chairman, no, I asked for it to reflect exactly the definition from the
Then I led
previous
it in the
bill.
wrong direction. Can we do a cleanup to that just to say, and it would have the same language for the investor-owned utilities, the other utilities? And it's my fault. I missed it. So I was thinking we were just having an amendment with respect to cooperative, and that's what I called it out. So I'd like to say, let's further amend to match exactly what we did with both cooperatives and the non-cooperative utilities. Is that acceptable? Can I at least get a motion on that?
Yep.
One, and I've got a second. All those in favor signify by saying aye.
Aye.
Opposed, no. So that matches in both categories now. And I'm sorry, I missed the turn in the road. Anything else on the bill? Anything else on the bill? Katie, would you call the roll?
Mr. Chairman, this is roll call for 24 LSO 0275, Public Utilities Energy Resource Procurement as amended. Senator Barlow? Senator Boner? Senator Landon excused. Senator Scott?
Aye.
Representative Chadwick? Representative Haroldson?
Aye.
Representative Harshman excused. Representative Knapp?
Aye.
Representative Newsom? Representative Ottman?
Aye.
Representative Wiley? Representative Yin?
No.
Chairman Case?
Aye.
Chairman Olson excused. 10 aye, 1 no, 3 excused.
Okay, well, got another one. I think we're done for the day, aren't we? Mr. Taylor's happy. Some people, utilities are happy. No, we have one more bill. It's actually quite significant. It's short, but significant. And it is 24 LSO 276, third-party electrical generation. Josh, please.
Thank you, Mr. Chairman. Josh Anderson, LSO. So yeah, this is the final of the 4 bills that were requested at the end of the last meeting related to third-party electrical generation. The bill as drafted would, under the definition of public utility, specify that none of the provisions of this chapter shall apply to the generation, transmission, or distribution of electricity by a producer that is not otherwise a public utility if the producer sells the electricity to not more than 5 retail customers and does not use any public utility facilities.
Thank you, Mr. Anderson. Questions for Mr. Anderson? Thank you. Mr. Burbidge, do you want to start?
Thank you, Mr. Chairman. Again, I'm going to be relatively brief on this one. The commission in February engaged in rulemaking to address this issue and held a technical conference, and we've since held a second technical conference furthering the rulemaking process. I guess my only comment with this proposed legislation is that perhaps it shouldn't be as specific, but maybe allow the commission to establish this sort of exception through rulemaking. We are discovering that there are many, many issues surrounding this concept. As a little background, our effort and our endeavor to start rulemaking really came at the idea that small nuclear power producing facilities were going to be available in the next 10 years, and that rather than reacting, it's a bad
It's a kind of good
bad
pun,
word to
actually.
use,
I like
it just came out that way. But that perhaps we needed to get ahead of the curve on that, because it appears that it is most likely viable, and it is an option that I know that some industrial consumers are looking at. And it's not an issue that we believe that we can be playing catch up on in the event that these things come to fruition. We have been receiving some inquiries, along these lines, but I think with where we're headed with this, that if it was less specific, but again, allowed us to continue our process with rulemaking, I think that would be a good change to this particular proposal.
Thank you, Mr. Burbridge. And just asking conceptually, or is the rulemaking, is there any limitation to the rulemaking? For example, this bill says that they do not use any public utility resources. So that literally, I think, says they can't sell power back to the utilities, is the way I read that. So I have a hard time imagining why you'd want a nuclear power plant if you didn't have the ability to sell power back into the grid. I mean, you got 5 different customers, for example, buying power from that, and they have different operational characteristics, and you can't cycle that nuclear plant very easily. It seems very complicated. So I'm trying to imagine, does your rulemaking envision those kind of limitations or not?
Chairman Case, that is actually a big issue that we're grappling with in the technical conference phase of
Okay.
what we're trying to put together as a proposed rule. And part of that's combined with how much involvement do the utilities want to have with this or be obligated to serve?
Yeah.
We're discussing, individuals that may want to have the ability to be connected to the grid for backup power purposes in case they have outage issues inside the fence. And of course, the utilities are concerned about, well, what obligations do they have? And so we're looking at exactly what this draft says, which there's no use of utility facilities at all, but then the realization that maybe there is, and maybe you end up with that. And they are difficult issues. And we're tackling those, and there's a lot of disagreement as to, well, number one, the concept alone is pretty controversial, and understandably so. I'm aware that the cooperatives are not real excited about this idea.
They'll probably get an exemption. You wait and see.
What we started out with was, as far as the proposed rule that we put out there for comments and, a call for comments and the technical conference was pretty basic, and it's gotten a little bit more complicated as we moved on. So
It's a big thing to get your head around. Questions for Mr. Burbridge? Thank you, Mr. Burbridge. Oh, Senator Scott, I'm sorry. Go ahead, Senator Scott.
Mr. Chairman, discussion has been in terms of small nuclear power, but Mr. Chairman, the way it's written, my question, Mr. Burbidge, is, am I reading it correctly that it wouldn't necessarily have to apply to nuclear, that if the price of power got out of line, some of the large industrial customers could get together and essentially put together, say, a natural gas facility or something that would serve them. Am I reading that right?
Mr. Burbridge.
Mr. Chairman, thank you, Senator Scott. In the rulemaking that we're discussing, it is not limited to just nuclear facilities, and it does contemplate the idea that we're aware that you might have areas where, for instance, somebody's a producer is flaring gas, but would instead use that to generate electricity for themselves at the site, but then perhaps sell that to a third party. For instance, if just as an example, you might have a blockchain or a Bitcoin miner that would want to pull a trailer on site, and if the producer had excess electricity from their own generation to run their compressing whatever it is they're running out there, that they might be able to sell that then to a third party on site to do something else. So it goes beyond just a nuclear facility. That's true.
And Senator Scott, I think our bill also is any form of, it's just an electricity producer. It doesn't specify the technology. Yeah. Yeah, anybody else? Representative Yan?
Mr. Chairman, so I'm trying to envision another situation, which is, and you're saying you're not sure on what a utility's responsibilities could be, but let's say I want to sell to Microsoft or the other data centers in Cheyenne, and I just set up a bunch of solar panels and say, here, buy my solar, and then you can get the rest of your load from Black Hills. Is that something that they could do under this bill?
Mr. Burbidge?
Mr. Chairman, Representative Yin, this is another topic of discussion. I think that this bill, I don't know. Okay, I'm going to say that. I do know that we've discussed the idea that at one point in time, that it could only be new customers and not existing customers, but I think we're past that. I think that now the discussion is where do you come up with the number 5, or where do you come up with the number 4? But I'm not certain that we've yet discussed the exact scenario that you're talking about. So
I think for right now, we just
Yeah.
have to go with the language in the bill.
Yeah.
And it says that the producer sells the electricity to not more than 5 retail customers and does not use any public utility facilities. That's the producer that's not using it. Yeah, so that's the producer. That's not necessarily the customers. I think that's going to be an important point as we go on a little bit. So, Mr. Brewer.
And Chairman Case, I'm reasonably certain that Mr. Nelson will have
Some comment on that?
some opinion and comment on that very question from Representative Yin.
I think he will too. Anybody else? Any questions for Mr. Burbidge? Thanks, stay by. We're getting
Thank you.
close. Mr. Nelson, should we throw you up there first? Or next?
Thank you, Mr. Chairman, members of the committee. All right, this is the shortest, but undoubtedly the most difficult and controversial of the legislative proposals that you have before you here today, and we get that. Let's talk about a couple of things and lay some foundation for this. One of the challenges in Wyoming is that it is actually a little bit legally ambiguous exactly when someone becomes a public utility, because the statutes in Wyoming contemplate that public utilities serve the public, but it doesn't say what that means. Is one person the public? Are 3 people the public? Who is the public? And so we have some legislation that doesn't make that clear. We have some case law in Wyoming that talks about this, but not a whole lot, because we don't have a whole lot of case law in Wyoming, and that's a good thing. But it creates this ambiguity. There are many groups of customers, and I'll give you a couple of examples of who is it that wants to do this? And they fall into these categories. First of all, already in Wyoming, in particular on the large industrial side, many customers have behind-the-meter generation that they operate. That oftentimes is coal-powered or gas-powered. Most typically, occasionally we're seeing now a couple of renewable facilities. But what behind-the-meter means is that you have an industrial site, and they have a power plant usually located inside their fence on the industrial site. And that power plant essentially plugs into the site on the customer's side of the utility meter. So that means that the utility doesn't even see the power supplied internally as load. They only serve what is not already being served by the inside the fence power plant, essentially. And the idea with this legislation is to make it possible, clearly, to have small groups of customers who want to do the same thing collaborate. Because one of the challenges of doing the small-scale nuclear projects that have been discussed, or slightly larger, more efficient coal or gas-fired facilities, is if you can make them a little bit bigger, you can make them more efficient. And so the concept here, and there's 2 specific examples I'll give you. You have, number 1, the Trona mines out in the Green River area. All of those mines are very, very geographically close to each other. Many of them already have some version of behind-the-meter generation. And under this legislation, what they could do is they could pool their loads, build something bigger to serve all of them, build their own wires to connect to the different mines, each behind the meter of the utility. So the utility then only serves whatever power is not being served by that, essentially that slightly, I'll call it the sort of central power station, if you would. That's the idea of who this is really targeted towards. Another example that we see is we have a number of oil and gas fields in the state where you have multiple operators who are sort of operating on top of each other. And several of them have already been exploring the idea of building, mostly in their case, gas-fired, oftentimes waste gas-fired generation to help run their pumps. But because their fields are like right on top of each other, if they could collaborate on those systems, it would be able to do that much more efficiently. Again, most of those oil and gas fields, as the committee may be aware, operate their own kind of independent distribution systems for the electricity. And they have like 1 or 2 points at which they interconnect with the utility. And so in this context, that would be how that would help them. Now, having said all of that, I'll say a couple of things. One of the critical issues that has always come up with this kind of discussion is if we go down this road and we allow people to do this, will that hurt residential? I'll say a couple things about that. First of all, as a practical matter, this is designed and is written that residential and small customers could also take advantage of this. Now, to the question that was raised by Representative Yin, if you imagine you have a cul-de-sac of residential homes, all of whom want to have solar power, you can imagine they could build one sort of solar facility sort of in somebody's backyard, larger than you would put on somebody's house, connected up to 5 different homes, and you could do the exact same thing on a micro scale if you found enough similarly minded people who are willing to incur the cost of connecting up the wires from the generator to each of their homes. And so there's that. The other thing which is true is if we're talking about Rocky Mountain Power, one of the great things about Rocky Mountain Power is that they operate in this 6-state region. What that means is that if, for example, we'll take the Trona companies as an illustration. If they built a nuclear facility to help supply their mines, and that lowered the load that those utilities buy from Rocky Mountain Power, under the way the multi-state agreement exists between Wyoming and the other 5 states, if Wyoming's load drops, that shifts the costs of the system to the other states. And so in that context, we already have a system in place that provides for that shifting if the load is dropping in Wyoming. It is also the case that over the next few years, we will be experiencing, unfortunately in some cases, but we will be experiencing the retirement of many coal-fired facilities. And if and to the extent we enact this legislation now so that customers can take advantage of it, when the utilities have to build replacement power to replace the loss of the coal-fired plants, if, for example, the Trona folks have already built their own nuclear or coal-fired or whatever facility, then they simply, the utility won't the replacement power to the same size, and that saves everybody money. And so for Rocky Mountain Power, I think there are a couple of reasons not to be afraid that this is going to affect the residentials. That is less true, in all honesty, for the other utilities and for the cooperatives. Those folks are in different situations. And it is more of a concern, to be perfectly honest, that if you have a group of customers who opt to supply themselves power, that may leave costs that need to be picked up by the other customers of that utility, and that could be a problem. So I don't want to sugarcoat that. That is a fair question and a fair consideration. I will share for those members who recall, a couple of years ago, why I worked on legislation designed to help promote behind the meter generation. And after having a long discussion with the commission and long discussions with the committee, the legislation was, I don't remember, Senator Scott, it was like 8 pages long because it dealt with a lot of complicated situations and issues. And this is much more simple. And I don't want to hide the fact that there are complicating questions that go with this. The last thing I'll just mention, and this is now I'm going to make Mr. Taylor earn his money. Unfortunately, I don't think this is a statute that lends itself to exemption because under the law right now, there's only one definition of what a public utility is. And so if you exempt that and create sort of different definitions of what a public utility is or not, you're going to have probably pretty significant problems in all the rest of the statutes in terms of how that works out. And so I would for good or for ill, I don't know that this particular statute isn't one that can be easily exempted. And if the exemption is something that the committee wants to explore, I think we can absolutely do that, but it's probably going to require a different framing of how you might approach this issue than tackling it the easy way, which is defining who is and isn't a public utility. With all of that said, I guess I will leave the committee with this thought. WIAC definitely appreciates the process that the commission is using to consider this question through rulemaking, and we are and actively participate that. I will say that it is an odd little process because the last couple of meetings, it feels like WIAC is the only one in that room who says, hey, we need to try to do something differently. And then you have like 15 cooperatives who say, that's a terrible idea. And it sort of feel a little bit alone sometimes. But be that as it may, that process is ongoing. And I recognize that this is a budget session coming up for you all. So I would understand and I would appreciate that if this is not the right time or the right vehicle for this, that it might make sense to maybe do it in a study, maybe do it in a full session later. But from WIAC's perspective, this is an opportunity for Wyoming. And customers have an opportunity to create generation options in Wyoming, nuclear, coal, and gas-fired, that will create taxes, that will create jobs, and that will create stable electricity supply for the industries that Wyoming depends on. And so from our perspective, this is an issue that we want to continue to keep front and center. And whether this is the right time or not, I'll leave to you, but I really appreciate the fact that this consideration is coming.
Questions for Mr. Nelson? Mr. Nelson, before you get off the podium, could you talk to the committee about how Wyoming is different than other states because of the size of the industrial load?
Yeah, sure. Mr. Chairman, members of the committee, one of the things which makes Wyoming quite a bit different than states like Utah in particular, for example, is that the industrial load in Wyoming is an extraordinarily high percentage of the overall loads that the utilities serve in this state. That's true, maybe less so for MDU, but it is definitely true for Black Hills and for Rocky Mountain Power. And so the implications of that is there just isn't, like you have in the Wasatch Front. I mean, there isn't this vast pool of residential customers and small commercial customers who are available to sort of deal with the implications of a large industrial customer coming or going. And so that definitely creates some challenges in terms of how this kind of legislation might be implemented and the impacts of this kind of legislation. It also creates some opportunities, but I think it is always important to bear in mind that we are a little bit different, and we want to be, certainly WIAC has never wanted to and has always been very supportive of making sure that we are protecting all customers in Wyoming. My predecessor, a guy named Bob Pomeroy, every time he would make a presentation to the Wyoming Public Service Commission, one of the things he always said is, look, 90% of what we do benefits everybody in the state of Wyoming, and we are proud of that. And we don't want this to be any different. But at the same time, we have opportunities, we think, for Wyoming to engage in a little self-help here in terms of getting some new generation in the state, and making that process work a little bit easier would be a big help.
Thank you, Mr. Nelson. Okay, any other questions for Mr. Nelson? Thank you.
Thank you.
Well, our next contestant is coming up. It's going to be Mr. Acey. One piece to remember is that these large industrial customers, they're mostly, to a very large extent, they're involved in resource extraction, the trona mines and oil and gas. And so they face worldwide competition. They're important to Wyoming. That's one argument. I'm going to push back on them and say, well, they also have to be where the resource is. And, they're stuck here. So we're partners. Mr. Acey.
Thank you, Mr. Chairman and members of the commission. My name is Bruce Acey.
Committee, I know. We're sounding like a commission today, but we are a committee. Yes, you did,
Committee,
sir.
sorry.
Wow.
I apologize for that. I'm here on behalf of Montana Dakota, and we oppose this bill. I would note, just as Mr. Burbridge has mentioned to you, that we did participate in the regulatory process with respect to the proposed regulation that the commission did propose. In that venue, we suggested to the commission that they didn't have the authority to extend it as far as they did, and by coming here, they would obtain that authority. And so I really kind of a circular, argue there one way and argue here another. But it really comes down to the policy that this body would like to do. Years ago, I was in a rate proceeding with Mr. Spence, and he came up with this Mrs. Murphy, does it hurt Mrs. Murphy? You just heard the idea that this is an opportunity for Wyoming. I'd suggest it's an opportunity for large industrials because in fact, there's no way you can get around the idea that this is going to hurt small customers who have no independent authority to protect themselves. They rely on consumer groups, they rely on the legislature to protect them. And as a matter of policy, you have to make the policy as to who you protect. In this case, this is a very simple bill, and as is pointed out already, it's very easy to start coming up with all kinds of concerns and situations that would be very complicated. And the implementation of this bill. The main thing that we always seem to be concerned with is price, 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 price. And that's important. That does make our product less expensive on the international market so that we can sell our product internationally. That's important. That's important to this legislature. But in the same sense, there are other issues that are important to utilities, and that's reliability. If in fact this didn't work out and this marketing didn't work out, and let's say instead of a small nuclear plant, it was a snake oil salesman that's selling a product, and it didn't work out, where do they turn? Certainly they turn to the legislature and say, what do we do now? If they're not going to use any utility product and service or transmission line or whatever, where does that leave them in that circumstance? Well, the one thing the utilities do is they do, and you've heard all of the bills we've talked about today with respect to long-term horizons, 20 years, 5 years, and looking at this horizon. All of those bills that you're passing to build in reliability and predictability for customers, none of that would be available. They all anticipate that they would have a backstop because they could come to the utility for that service. But if they do that, we have to build in the price so that we cover our consumers. We take care of Mrs. Murphy. Large industrials don't really care about Mrs. Murphy. Utilities have to, because we have to respond to you. And because of that, there are concerns that we have with this bill. We believe that there are opportunities. And we believe that in the past, whether it's border anomalies or whether it was a special circumstance, we can develop tariffs to address these things. We have flexibility and we can do that. But when we do that, we look at the whole picture. We look at what the impact is on Mrs. Murphy, as well as the benefit to the industrial customer that might want a benefit. And in analyzing that whole situation, we try to come up with a tariff that is truly fair to all. And I don't think this legislation does that. It does give the commission a little more power and gives them a little more flexibility. And maybe in doing that, you're allowing them to use some of the authority that they would receive to act in the public interest. And ultimately, that's what you're trying to do. I don't think this bill does that in the sense of protecting all consumers. And so we do stand in opposition to it. And I'm here and will accept questions that you might have for me to the extent I can answer them.
Thank you, Mr. Acey. Questions for Mr. Acey? Thank you.
Thank you.
Who's next? Mr. Bush. Welcome, Mr. Bush.
Thank you, Mr. Chairman. I will try to be brief as I know it is now almost 5 o'clock. We also are opposed to this legislation, surprise, surprise, for many of the reasons that have been laid out, including the impacts that we see would come to other customers if, say, a third party was allowed to come in and cherry pick our larger industrials. The way that the accounting works on that and you know, the design that we have of our system to serve that load and the benefits that that then provides to smaller customers would be greatly impacted. Some of the, I guess, more philosophical questions I have about this, we talked earlier a lot about reclamation. So if we have gas, nuclear, whatever site it may be, what happens if that third party corporation goes out of business? And we're left with some sort of a generation site that's just sitting somewhere. Is there any sort of reclamation provisions? Do they have to pay for that? What happens with that? I think there's also some questions about how this could work if a third party setup, could they set up several different LLCs and all of a sudden you have a umbrella corporation with several LLCs serving different customers, and then at what point are they still not a public utility if they're serving several different customers that way? So I think there's just a lot of questions with this. There's also, again, I think the big one is this is not good for a lot of customers in Wyoming and really raises a lot of questions that have been, I think, covered in previous testimonies. We had this similar legislation with the deregulated industrial power zones bill that came up last year. I think it was last year. We had over 30 hours of testimony on that, and the slippery slope of deregulation that we were heading down and how that would impact the state and the customers. There weren't very many people in favor of that, but again, there are a lot of questions, and I think there's more harm than good that could come from passing this legislation for most of the customers in the state of Wyoming. So,
thank you, Mr. Bush. Questions for Mr. Bush? Questions for Mr. Bush? Thank you very much.
Thank you, sir.
I like your hyperbolas you threw in there. Who's next? Mr. Garlish. Do you get to go home for the weekend? Maybe?
I don't know.
The rest of the crew over there at the commission, are they heading south yet?
Mr. Chairman, they're already going home.
Wow.
And
And you're holding the front. Welcome. And
that's
thank you.
fine. It is late in the day, and I agree with Mr. Bush and Mr. Acey, and I would just observe that while the bill may be short, the policy questions and the list of unintended consequences associated with this bill are long and heavy. We went through them in the deregulated zones, 30 some hours. We've talked about them at length. It's deregulation, pure and simple, and that's never worked anywhere it's been tried. So for those reasons, we oppose the bill.
You gotta stay close. You can't stand up. Questions for Mr. Garlish? Representative Ottman.
Yes. Yes, I'm wondering if there was a larger business that was out in areas doing their business where there isn't a utility there, and there isn't going to be, does this provide that they could create their own electricity so that they can perform their business?
Senator Case,
ahead.
Representative Rotman. I think this goes back to like the fundamental principle of a public utility. You know, the reason, the idea, the concept behind a public utility is that in order to take advantages of economies of scale and build facilities that are big enough, generation, transmission, and distribution, to lower the cost of those, because they're all very capital intensive. And in order to lower the cost of those types of facilities, having sufficient load or sufficient customers to spread those costs across is in everybody's benefit, and in that it lowers rates. It is generally cheaper than groups of generation being built to serve specific loads. And that's how we've kind of got to the modern public utility. So in your example of how it would work under the current kind of paradigm is that if, you know, chances are that business would be in somebody's certificated service territory, be that a co-op or an investor-owned utility. They would look at that and what would it take to integrate that load into the system. And so there'd be an investment, let's say in generation or transmission or distribution lines to do that. And then Mr. AC's point about we have ability under tariffs and special contracts to be able to figure out what a just and reasonable rate is. That allows both the residential customers, there's different customer classes, right? There's commercial, industrial, residential, how those costs would be absorbed and the benefits spread across the load, the larger load. So I respectfully, I don't think that the situation that you described exists. And if to the extent it does, the current regulatory system accounts for it and has mechanisms to provide that benefit both industrial customers and residential customers and the reliability of the bulk electric system.
And I think, Mr. Garish, if you would let me tag on, in the case where you have a customer isolated plant and they build a generation facility and they serve themselves and they own it, I think we all agree that that would be legal in Wyoming. I think we agree to that much. The question is, can someone else build a generation plant, even if it's behind their plant, and it be owned by someone else and serve that load? Or can customers get together and have a common plant? That's where it all starts to fall apart. But a single user of electricity that owns the facility, I think that's clearly legal in Wyoming, which is the narrow part of your situation. But as soon as you have any combination from thereof, it becomes first murky and then not permitted. And it depends on people's interpretation. Is that fair?
I think that's very fair, Chairman.
Thanks. Okay, any questions for Mr. Garlish? Thanks.
Thanks.
Who's next? It's Mr. Pickard. Mr. Overbuehler. Wow, this is quite a pairing.
Late in the day.
Go ahead, yeah, sure.
Good afternoon, Mr. Chairman, members of the committee. My name is Dave Pickard. I'm here representing Merit Energy Company. We're an oil and gas operator up in the, primarily in the Bighorn Basin. We're been operating up there for about 100 years. It's a very old legacy field. We support this bill, and here's the reason. In the year 2020, 750 million barrels, I figured you were going to think that I was going to say oil, but not. 750 million barrels of water we had to produce, pump, and repump to produce the oil. We're the fourth largest oil and gas operator or oil company for 2019 figures in the state of Wyoming. It's extremely expensive. We do have some self-generation that we're trying to bring online, but we're an oil and gas company. We're not an electrical utility company. So the reason that we support this is if we were able to go to a third party, and even if it were that third party were to only generate for us, that would be beneficial and lower our costs. You know, I heard about Mrs. Murphy. I suspect Mrs. Murphy is pretty close to, you know, the equivalent of my mother, who's 90 years old. And I would argue that Mrs. Murphy and Mrs. Pickard benefit immensely from increased oil and gas production because of our tax structure. the amount of money that we generate and can generate without shutting in because of our high production costs, primarily due to electricity, is a significant factor for Mrs. Murphy. So yay for Mrs. Murphy. And with that, again, we support the bill and stand for any questions. Thanks.
Thank you, Mr. Pickard. Any questions for Mr. Pickard? Thank you. Mr. Obermuller.
Mr. Chairman, Pete Obermuller, Petroleum Association of Wyoming. Good to see you.
Welcome.
The committee deserves a gold star. This has been a long couple of days. Appreciate all the work that you do. Mr. Chairman, I think you've heard me say a million times that second only to labor costs are the costs of electric power for my members. That is pretty much true across the board, whether you're a large company producing in the Powder River Basin, or you're a legacy company like Merit producing up in the Bighorn Basin, or you're a small mom and pop company just out trying to turn wrenches and produce a couple of barrels. Power costs are enormous, and every part of power costs is going up, whether it's from the Rocky Mountain Power rate case or from any other inputs that are causing this to go up. This is just the reality. And the fact is that we are, quite frankly, desperate for options of how to control our power costs. And the bill in front of you today, it may not be perfect. And as Mr. Pickard pointed out, from my perspective, my members don't even necessarily need to be part of a consortium. They just need to have an option. And you can build it yourself, but particularly my smaller guys, they're not a power company. They don't have the expertise to do that. So having the ability to hire a third party to produce your own power is an option that could reduce our costs in this particular realm. So we appreciate the discussion and hope that it can move forward. Thank you, Mr. Chairman.
Thank you very much. Any questions for Mr. Obermuller? Thank you. Who's next? Mr. Taylor, welcome. Thanks for being so patient. Oh, you got the crew. I recognize some of these folks. Welcome. Thank you for being so patient.
Thank you, Mr. Chairman, and I'll let all these folks introduce themselves as we go down the way. Sean Taylor on behalf of Wyoming's Electric Cooperatives. A couple things. First of all, I want to appreciate you giving us the opportunity to comment on the territorial integrity bill that was not brought back to the committee today. And I'll just give you a very brief update on that. And the reason I said we would just
It's a good time if you want to do that.
I just said, the reason I said we'd do it during this discussion as well is because it's two sides of the same coin. We're going to be up here asking you to oppose this bill for the same reasons we're going to ask you to support a bill when we get it to you to protect certificated service territories. I appreciate Senators Barlow and Landon, their commitment to helping work with us and all interested parties to get you something. We didn't want to rush it. That's why we didn't have something for you today. But since the last meeting in Douglas, we have had another incursion by a large customer that's built into another or same cooperative service territories we discussed before. And this time it was without knowledge by either utility, either the incumbent utility or the neighboring utility. They just built it, hooked it up on their own, and nobody was the wiser. So that's why it's vitally important that we have a bill like Senate File 105, the territorial bill, to you this coming session. Regardless, it's a budget session, but you can see from this latest example, if nothing happens, then this is going to continue to happen, and it's going to continue to impact the cooperatives that are usually the ones that are getting encroached upon. So to third party, I'm not going to ask for an exemption. We're not going to ask for an exemption because this is just a bad idea for the entire state. A couple points that I want to make at the technical conference that the PSC held last week, and I think Mr. Nelson alluded to this. Of the 16 comments that were submitted, 14 of them were from rural electric cooperatives and G&Ts. I think that should tell you. And if there was only one entity in support of it, that should speak volumes to you. And finally, I would like to just note that.
Well, would it be fair though to say that one entity was an association?
Yeah.
Yeah, I think that's important. Thanks.
But I want to just say that Mr. Nelson's explanation of entities bounding together or coming together to, economies of scale, hopefully get cheaper power, sounds an awful lot like a co-op. That's what we did 80 years ago, right? Nobody would come serve us. And so we banded together, built our own lines, built our own generation. And now we're going to be punished for it if, and as you said, Mr. Chairman, a lot of these large industrials have to go where the resource is. And sometimes that happens to be in our service territory where nobody wanted to serve that before except the cooperative. So very similar explanation there. So with that, I'm going to turn it over to these folks that I've been waiting patiently and traveled down here to visit with you all to talk about the third-party bill.
Thank you, Mr. Chairman, committee. Derek Eisenbrown here on behalf of High Plains Power. I'm the CEO. Just wanted to make some comments. A lot of them have been already addressed, but the fact of is you start carving out pieces of our service territory. High Plains Power serves about 10,000 members across 5,000 miles of line across central rural Wyoming. I'm really going to emphasize the rural. We serve across 9 counties. About 70% of our revenue currently comes from large CNI customers, which inevitably, obviously, if you carve those sections of it out, we're still obligated to maintain those same 5,000 miles of transmission and distribution lines to serve power to the water wells, the rural residential, the farms, the ranches, all of those things.
My church.
Your church, exactly.
Yeah.
We're here in opposition to this bill. It is deregulation. I think that was kind of touched on earlier, but I want to emphasize the fact that it certainly is deregulation at its simplest form. And I believe it would be very harmful to many of your constituents, which are rural, central Wyoming. Thank you.
Thank you. Good to see you. Yes, sir. Green light.
Thank you. And thank you, Chairman Case, for your comments and compliments towards the cooperatives this morning when you started this process. Appreciate it. Today, I'd like to present language from a letter to Chairman Throne from Russell Waldner, the General Manager of Carbon Power and Light. And I quote Mr. Waldner: "For all the reasons my cooperative counterparts have so clearly articulated, I also oppose any rule that limits my members from enjoying the benefits of the public utility's ability to flourish with increased economic activity in our certificated service territory. If an industry cannot see the benefit of being a contributing member of the public and simply wants a better deal, that industry has failed to recognize the opportunity that we have collectively created for them here in the state of Wyoming." That's pretty simple language that really says it all. We are entitled to provide for the rancher 70 miles northwest of Lusk in the Grasslands National Forest out there. What happens if we lose our big economic, large-scale commercial consumers? What if they do pull in somehow a modular economic reactor? If we lost our load from our pumping stations northeast of Lusk, the membership of our co-op would be severely hurt. And so we as Niobrara Electric, we oppose this bill. Thank you.
Thank you, sir.
Thank you, Mr. Chairman. I'm Shauna Glendy, the General Manager at the Niobrara Electric Association.
You might pull that just a little bit closer.
Never been
You
told
can
I
pull
wasn't
move
loud
the
enough
microphone.
before.
Yeah, you can move closer. That's okay.
So as Sean already mentioned, our territory was invaded by another unregulated entity. They actually built line into our territory. It's privately owned, and then they're taking power from an IOU, our neighboring IOU. That is what is a big hiccup, and we filed a complaint with the PSC to no avail. We asked them to order the IOU to stop serving that load in our territory. That did not happen. The IOU says, we're not going to stop serving unless we're ordered to do so, because since we're regulated, we have an obligation to serve. So it puts them in a really bad situation because if they stop serving when they're not ordered to, they could be sued because they're not meeting their obligation to serve. On our end, we're losing millions of dollars at this point in revenue for our members. And like you alluded to earlier, our territory is 5,400 square miles. We serve 1.4 meters per mile. We are very low population, low income, and when we lose that type of revenue, we have, our system was built in 1941. Our lines are 61 years old. We need that new revenue to be able to replace that system for reliable power. So when you allow unregulated entities, such as oil and gas who are building lines into our territory, and we can't do anything about it because they're not regulated, kind of the same thing that you're asking with this bill. You want unregulated people to come in our regulated, certified territory and expect us to be able to provide them power if they can't serve our load that they're taking in the beginning. It's just, the model just doesn't make sense to me. I mean, if they're not going to be regulated, why would we be regulated? Because it's not a fair fight in any way. Like JD said, 61% of our revenue comes from 7 members, large power and industrial. If you let somebody come in and take 5 of those, we are bankrupt. We can't serve 1.4 meters per mile and lose that type of revenue. So I guess I would strongly oppose this bill and ask that, if people are going to generate electricity and sell it, everybody needs to be regulated and everybody needs to have a certificated territory.
Thank you.
Thank you.
Any questions for the panel? Can I ask one question? Your last statistic about the large customers, you said how many customers and how much percentage of power do they have?
7, and it's 61% of our revenue.
So 7 customers, and I'm going to make a point here and you're not going to like it, but 7 customers take 61% of your power. Do those 7 customers have 61% of the control of the company?
No, because we are co-op.
Right. And that's kind of the problem. And it's a benefit and a problem, but.
Yeah, and I understand your point, Senator Case, but we are non-profit. So that load or that money gets back to each of the members based on our margins at the end of the year. And it's based on how many kilowatt hours you purchase. So if they're buying 61% of our load, they're getting a much higher return than somebody who, only has a $100 bill every month versus.
And you're of course referring to the dividend check that most co-ops get. Church got a great one this year, by the way. So they get the benefit on the back end when the dividend checks come out, but they don't set the rates. You know what I'm trying to say? So the rate structures are all real important in this. In fact, if the rate structures were such that these entities didn't have to go somewhere else, they would willingly stay with you. And I don't have an answer here, but they don't get to set the rates because the rest of the representation that has less than half the power sets their rates. And that's always been the rub with me in the deregulation part of the co-op deal. But that's just a point I'm going to make, and I forgive me for doing it. That's one way that I look at it. It doesn't change the basics, but who's.
Yeah, Senator Case, I'd address that too, because we're different yet similar from Shauna, and most cooperatives are different.
Every one of you different.
While I would offer that every one of these members, large or small, has an opportunity to run for the board of directors and have representation. And
but they get one vote, right?
They do get one vote, yes, absolutely. But at the end of the day, that's how cooperatives were founded, right? One member, one vote. That's democracy. That's how a lot of us are here. So I guess just from the standpoint of saying that cooperatives are, I don't want to put words in your mouth, but overcharging large industrial consumers or not giving them the voice that they're warranted, I would just say that's not necessarily true everywhere.
All right, I'll let you get away with that. I appreciate it. Questions for these people doing a great thing for our state? Anybody? Mr. Taylor, you do a heck of a job. You always get the heart tug at the end and you bring it home. So thank you very much, sir. All right, who else would like to address this? Thank you. Drive safe. Who else would like to address about this bill? Mr. McNiven. It's a big Fremont County day. Go ahead.
Thank you, Mr. Chairman. My name is Travis McNevin here on behalf of Basin Electric. I would have joined the contemporaries or colleagues here if there would have been 5 seats, but I will come up and do that at this point. As the committee knows, and I will be brief, Basin Electric currently serves about 167,000 end user customers, the 11-member cooperatives, about $2 billion in total investments in Wyoming, 400 miles of transmission lines, 19 substations, around approximately 350 employees that directly working there. Primarily, Dry Fork and Laramie River are the 2 primary power stations, of course, here. It will come as no surprise. Also, strongly oppose this bill for many of the same reasons that have already been addressed, and I will not reiterate them, but simply maybe hit a few bullet points that this form of deregulation simply would do. One, undermine system stability and reliability, increase potential stranded or underutilized assets, make short and long-term management and planning much more difficult, make prudent and needed long-term investments less likely, stifle economic development, reduce the predictability and stability of rates across the cooperative areas. I think a lot has been spoken about the user classes, and so I won't go into those again. But I would add one more, that particularly in these areas, rates would also increase for all of our local governments, your cities, municipalities, counties, et cetera, that would have the same impacts on their budgets as the rural consumers and users, et cetera, residential class. Also, further acknowledge Chairman Case about your point earlier about self-generation and behind the fence and utilizing it, that power themselves. That, certainly what can and be done. The question then becomes, as this bill points out, when it is transferred or to the 5 in this case of this particular bill. And then from the GNT perspective, I would add that there are technologies, one of which was raised earlier about the small modular, and that is something that, as the responsibility, low cost, reliable power for our member owners and the cooperatives, that is something that at Basin is being looked at what economies and in what sizes and at what times should that be utilized or deployed as a generation source. We're happy that the co-ops, Idaho National Labs were there, and I listened to some of the folks from Basin ask some questions that are much more intelligent than I could repeat to you today as it related to the technology and to the sizing, et cetera, of utilizing or bringing that in at when the economies warrant that. So that is certainly something that is in the wheelhouse of Basin, and as providing power and looking at all generation sources and types and technologies as they continue to advance. And so with that, Mr. Chairman, again, certainly are here in opposition to the bill today, and take any questions that the committee may have.
Thank you, Mr. McNiven. Questions for Mr. McNiven? Any questions? Thanks a lot. Who else would like to address the committee? Who else would like to address the committee? We got anybody online? Okay. Mr. Sweeney.
Thank you, Chairman Case. I'll
You should be
be
up
very
here.
brief.
You should be
Huh?
up here. You've been to a lot of late Friday nights on the Corporations Committee, but welcome.
I have. Thank you, Mr. Chairman, and I too will be brief. I am in favor of this, only from the position of if we could, I love our co-ops. I mean, and I don't intend to do harm but if everybody could negotiate a contract with some of these, I'm not saying they're being unfair, but there's got to be some give and take. That's where I believe this bill comes into play. And perhaps, just as a thought, maybe it shouldn't read 5. On page 2, line 14, it mentions not more than 5. Perhaps that should be 3. I don't know what the right answer is. But for some of our large consumers of energy, it's probably with modular nuclear coming of age, more and more is going to be possible. So with that, I am in favor, perhaps as a thought, if the bill moves forward, perhaps by limiting it down to 3 might be helpful. In somebody made the comment about cherry picking. I too would be concerned if I were a co-op. But with that, thank you, Mr. Chairman, for allowing me to testify remotely.
Thank you, Mr. Sweeney. Thank you very much. Questions for Mr. Sweeney? Not seeing any. Anybody else online? Anybody else in the room? Committee, you've heard the discussion. What is your pleasure? Is there a motion on the bill? Senator Scott?
Mr. Chairman, move the bill.
Got a motion by Scott. Is there a second on the bill? Is there a second on the bill? I'm not seeing a second, Senator Scott, and I can't give you the second. So I think it was a pretty valiant effort. So thank you very much. The bill dies for lack of a second. I suspect we're not done with this, and we'll be carrying forward. Senator Barlow?
Thank you, Mr. Chairman. So I am sympathetic to all the parties in this, and I guess I'm also very interested in how the process continues with the Public Service Commission and their technical reviews and rulemaking process, and I think that will help inform this committee, maybe in the next interim, about how we go forward. But I would actually ask that the folks, the proponents, maybe give me some feedback individually later on Romanet 6 of the exemptions. Romanet 6 is producer or person. And I guess that is something that I want to explore a little more, because it seems like maybe there is an opportunity. It's not 5, but there's still an exemption. That's the producer component. And then what does that other person mean? Has that been interpreted in some way by the commission or in the work that you've done elsewhere? So I'm curious about that. I'm sympathetic to the interest, but I want to understand what's already available and let the process play out. Thank you, Mr. Chairman.
Thank you. Anybody else? Okay, that completes all the bills. Small housekeeping that we do have a list of the election bills that was sent out occasionally in the past, and it's been more common than not. I thought that we would combine election bills just so we don't hit the floor with, how many bills do we got total? Do we know?
Mr. Chairman, I think we had 7 bills before today, and then whatever we passed today, so another.
So we're probably,
6.
we passed all but 1.
So 6 more, so.
Yeah, so that's 13 bills.
13 bills total.
And so the question is that sticker shock for our friends when we bring 13 bills? And we can go through the election bills individually on introduction, or we could combine them, limiting the title to what's in the bills. This is not an attempt to open it up, and I've heard a back rumor that somehow we're going to open up the election title. But you could conceivably take the bills limited by title, putting it up in the big title, and cover more than one section. Maybe not all of them, and maybe looking at the list of bills, they all shouldn't be. And maybe since there's only 6, they shouldn't be at all. We just divide it between the 2 houses. I throw that out there. Mr. Rubino's here, and I think he might have an opinion about it from the Secretary of State's office. And the Secretary's online. So let's hear from Mr. Rubino. He's here. And I see he's online. We're going to grab him. And should we go to the boss first? Oh, the senator.
Thank you, Mr. Chairman.
So, Mr. Secretary, can you hold 1 second? Senator Scott had his hand up. I think it's an accident. Mr. Secretary, to you.
Well, thank you, Mr. Chairman. And can you hear me okay?
Yes, sir.
Okay. Just want to emphasize for the media, I'm not driving, so pulled over. Had commitments today in Casper, tried to make it back after hearing about this, but wasn't able to make it back in time, so pulled over, and appreciate testifying remotely. First, I want to thank the committee for all your work during this interim. The committee worked a number of diverse bills, and those forwarded on are each tailored to unique scenarios and situations. And there are some things we didn't agree with, but overall, I think the committee did really great work. And just, I'm afraid combining these bills is a step in the wrong direction. This combination, which potentially could become an omnibus, wasn't noticed for today. And while there may have been omnibus or revisions bills in a few prior years, it certainly has not been the norm. And I have major doubts the combination has been done in this matter with a motion after each of these bills have been passed would not be a good way of proceeding. You know, I served for 6 years in the legislature. I know Senator Case, boy, is approaching, I think, over 30 across the House and Senate, but I served for 6 on, I believe it was 8 committees, and I've never witnessed this on a committee I was on.
Mr. Secretary, that is not true. And I just don't appreciate that. We frequently have combined election bills, and there's been a head up about it all the way through. I don't think we need to do that. You're making it in situation that is not true. So,
Mr. Chairman, it was never done on a committee.
because I can prove it. We have said all along we could possibly combine these. So, sir, I don't think people want to combine them, but if we combine them and remain within the titles, this committee has done that many times on election bills.
Mr. Chairman, I said on the committees I was on, it had never been done. It had been done 1 year on the Corporations Committee in 2020, and I don't think it ended up leading to more debate on the floor. That's the one time I witnessed it, but I was not on the Corporations Committee. I said I have never witnessed this on a committee I have been on. Senator
You do a
Case.
lot of
That's what I
anecdotal things, sir. I suggest we're not going to be combining them. But I think your imputation of my integrity and the fact that I'm trying to open this up has really got under my skin. So
Well,
it's
Mr. Chairman,
it's
I
a matter of
apologize for that,
convenience.
but certainly that was not the insinuation, Mr. Chairman, and it was not noticed. That's what I said. I didn't see it on. Is it on the agenda? Because I didn't see it on the agenda. That's
We
what I meant by not
repeatedly
noticed.
said it after each bill that we might combine them throughout the
I
year.
don't recall. That's not on the agenda. And how would I have known to testify? I would be down there today if it was on the agenda. So can I continue with my comments, or is that possible?
I think we're done, Mr. Secretary.
So you're going to cut me off
Mr. Secretary,
when it wasn't on the agenda?
Mr. Secretary,
Yes.
we have said all along that we might combine the election bills. We've repeatedly mentioned it.
Okay.
We
Can
said
I
it
move on to
yesterday.
substantively some of my comments rather than go back to the notice issue? Can we move on substantively?
We understand you're against it, and thank you. Mr. Rubino, don't extend, just make a quick comment, okay?
Thank you, Mr. Chairman. Well, as we discussed it at lunch, would you like me to go through my perspective, the office's perspective about the variety of the bills, the chapters that they span across, and just my concerns about the technical implications, or?
Sir, I think that point's well made.
Okay.
I appreciate it. I don't think there's any appetite for combining the bill. And so I withdraw the discussion about that. But let me be very clear, and I'm very angry about this, and it's because it was only done for the purpose of having efficiency in combining the bills with respect to the titles under election, so that we have one bill that has a better chance of being introduced than not. So I leave it at that. I kind of resent the way this has gone, and I'm sorry. I think I've lost my patience, and I apologize to the committee. I'm very grateful for your interim work, and I wish you safe travels home. With regards to the division of the bills between the houses, I will assume that it's okay with you guys if the chairman get together and look at where they should go, making considerations about workload and perhaps about whether the idea would be to support the bills and make sure they have the best chance of passage, no matter how the chairman felt about them. So to place them in the house that initially supported them might make a lot of sense, right? You guys good with that? Safe travels home. I think we're adjourned for the year. Very good work. Very good. Thank our staff immensely and very much appreciate it.
7. Fun little day.